Hey, what's up, guys? Welcome to Lagsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. Although right now, in an undisclosed location in East Texas that the internet has never heard of. Apparently, because, oh my God, what is up with this connection? It was fine the first night. It was fine the first night. But the past yesterday, tonight, oh my goodness. Oh my goodness. It has been bad. Bad connections all around. I'm handing out bad connections like candy. Here we are. Here we are. We have all sorts of stuff going on right now. Yesterday I started going through Ron and Monica's TCPA motion and looking at some of the evidence that's levied against Vic and saying, okay, can this actually stand? Will it, is this admissible or not? And so then we started going through and deciding what could stick around, what should be gone, what would you object to? And we did that for like 3 hours and got through a whopping 7 pages of the motion, just going line by line, trying to decide, is this hearsay? Does it point to a spot in the affidavit that would be hearsay? What can we get rid of? What can't we get rid of? And now some people are going to disagree with me a little bit on the analysis of some of those things. That's okay. This is done on the fly. I'm not an expert in Texas rules of evidence or the application of said rules, although it largely mirrors federal rules of evidence. I'm not an expert on this stuff, and me doing it for my own motions would take a significant amount of time and focus. We're doing it live. This is a simulation. So some people are going to disagree with some of my decisions, and that's okay. That's how this works. No matter what, for example, Ty were to turn in, Lemoyne is going to disagree with everything he says. So the fact that people disagree, cool. Disagree, make our cases on it, and then we'll see. Actually, we probably won't, because we won't make our cases on it to have it ruled by a judge, but Ty will. And what happened today, after business hours, was a filing. And this was actually Beard, Harris, Bullock, and Hughes filing to their motion to strike evidence from Funimation's motion to dismiss. So it's like the same thing we were doing yesterday, except in regards to Funimation rather than Rial and Toye. So that one has fired off. Funimation, of course, was the first TCPA. So makes logical sense that this would be the next or the first motion that they attack. So we're going to go through that document today. We're going to take a little gander, take a little peek at what they've got, see what they came up with, see what their reasoning is. And I've skimmed the document. I haven't read through it in depth or anything like that. Haven't had time. But we're going to see the full argument for each of the reasons to strike each of these things. And then what I'm doing in the background here, hopefully it's done. This internet has been, it's so bad. All right, let me just grab this. Download. Oh my God, download. Okay. I'm actually pulling up the motion to dismiss, and what I'm going to try and do is, like we were doing yesterday, we'll go through and mark off the stuff that they have marked off. And then I think, assuming I'm time efficient enough, which I'm not good at being time efficient on these things, but assuming I'm time efficient enough, we will have some product at the end where we can look at it and say, okay, if they win their motion, what's left? And then we can see what happens with that. We can kind of theorize about it. So I think law Twitter is a little confused. Some have suggested that, for example, a Texas lawyer who does First Amendment appellate practice, Lane, who I actually, like Lane and I have jousted a little bit. I largely don't engage him just because I don't find too much value in arguing on Twitter. I value Lane's opinion on this stuff because Lane is a practitioner in this jurisdiction on this issue. But I'm a little surprised by something Lane said today when in the hypothetical of me trying to strike portions of their evidence in the TCPA motion for Ron and Monica. Lane said, why are they worried about motions to strike right now? Because motions or evidence in motions are construed in favor of the non-moving party. So in this case, that's Vic, right? Vic is the non-moving party. Now, this was particularly, the discussion was revolving around the resume of Vic Mignogna. And the element of that resume is that on the resume, it says that he was from 1988 to 1990, I believe, that he was working for a company in Lynchburg, Virginia. And some people have asserted that goes to prove the truth of the affidavit of Robin Michelle Blankenship, 10 names. And so my question is, well, who authenticated the resume, right? This is the question. If you're going to introduce the resume, it has to be authenticated. Now, some people have suggested that Jay Sean Lemoyne authenticated that resume in his affidavit, including Greg Doucette, who cited Rule of Evidence 901B1, I believe, which is basically a witness who has reason to know can testify to the authenticity of a document. I don't think that exception actually, or that authentication actually applies here, because Jay Sean Lemoyne has no knowledge requisite to show that that is the actual resume authored by Vic Mignogna. That is some document that purports to be the resume of Vic Mignogna. They could have authenticated it by doing a document production demand, by asking him at deposition to authenticate it. They could have done those things. They didn't. Instead, Jay Sean just represents that it is this thing. However, they haven't laid the foundation in any way to suggest that that website was authored by Vic Mignogna or is authored by someone authorized to speak for him. It may be, it may not be. They haven't introduced evidence as such. And so since they pulled the resume off of that website, they similarly can't necessarily authenticate it. Now, Judge might disagree with that argument. However, I think it's a big problem. I think it goes to what we're seeing over and over and over from Monica and Ron's counsel. Sloppy lawyering. Very, like, for all of Law Twitter's bluster and bravado about Ty's filings, Jay Sean Lemoyne's filings are objectively terrible filings. They are poorly written. They are omitting steps of authentication. They're making very, very potentially fatal mistakes where they don't need to, and they're focusing entirely on the wrong area. They're so obsessed with the GoFundMe, right? They're so obsessed with the GoFundMe that they can't seem to focus on, easily knocking things out of the park, like authenticating this resume. They wanted to prove that he was in Lynchburg because I believe at deposition, they tried to nail him down on that Lynchburg, Virginia thing, and he said he wasn't there or something like that, that he was not present. Or they asked him if he worked at Liberty Christian Academy, and he said, no, I worked at Trinity Christian Academy down in Florida, which is a different school entirely. They tried to get him to admit to that, and I don't think they asked the right questions, and therefore he did not give them a proper answer for them to just go ahead and say it. So now they're relying on this document that they might be able to authenticate. Might, but they might not. And so, but I'm tangenting now. Here's the problem with all of this. Lane suggested that it was weird that they would try and strike evidence because the evidence is going to be viewed in favor of Vic anyway. Well, one, that's a silly approach. If you can strike evidence, strike evidence. No evidence is better than evidence that's viewed, you know, most favorable to you. If they don't have evidence to back up their claims, that's better than them having some modicum of evidence that's weighed more favorably towards you than the other. I mean, either he's in Virginia or he's not in Virginia. And if that's the only evidence that's presented, whether it's weighed favorably towards you or not, they're still going to say he's in Virginia because this is the only evidence we have. So rather than producing evidence to the contrary, they can just simply strike the evidence and claim a lack of foundation to make that assertion at all. That's a possibility. So I found that curious. I also found it very curious that someone who has been, I'm not going to say he's kicked Vic because I don't know that he has any sort of interest in the parties themselves, rather than just being opposed to the general filings of the lawsuit and stuff like that, in regards to Ty's portion at least. Someone who's been so openly against these filings and seemingly saying that this case is dead on arrival in TCPA, why he would suggest anything favorable and why they hadn't suggested that before. If all of the evidence is which, Lane, just so you know, I actually, a long time ago when talking about the TCPA, long before you guys had even seen the case, I did say in motions to dismiss that evidence is viewed in favor of the non-moving party. Specifically, I couldn't tell you which stream because I've done a lot of them, but I actually did say that. So yes, I do know that. We've covered that on this channel before, in this case and in other cases. But either way, if the evidence is always viewed most favorable to Vic, then Vic has a much better chance of passing the TCPA. And it's weird that they're not even conceding that at this point, because none of this evidence is actually offered to assert their affirmative defenses. Very weird. So they're banking entirely on Vic not being able to make a prima facie case, which I think is, again, poor lawyering, poor drafting. But enough of that. Enough of my soapboxy exposition on law Twitter. We'll see, and I know we'll see because we've got one motion to strike this stuff already in the dugout or on deck, in the end zone, sports metaphor. We've got that going already. So I'm guessing there's two more coming, right? If I just had to take a wild stab at that one. So we're going to look at those in just a second. I want to do a couple things before we get fully going on that. Let's pull over to this thing. Yesterday, I mentioned this charity. Someone did a super chat asking for people to help out. This charity met its goal just yesterday, or between yesterday and today. So very cool. I don't know if that was you guys. If it was, thank you. Thank you. If it wasn't, thank you for looking at it. But I thought that was pretty cool. So let's go to, let's pull this thing over. Let's go to, here we go. I'm going to pull up the GoFundMe here. This GoFundMe is kind of making me a little frustrated right now. They have claimed that they have completed the review and that everything is good. That remains to be verified. I'll try and verify that over the next day or two and let you guys know. But I mean, they are accepting donations. I know some people have had trouble. If you are individually having trouble donating to the GoFundMe, you can contact their little help desk, and sometimes they have this. Sometimes they just have to manually unblock your account. I'll talk about Doug and EVS in just a second, guys. Okay? I'll talk about them in just a second. But I just wanted to get a status update. We're 233,300 on the GoFundMe. Latest donors, Chris Wagner and James Carter. Thank you guys so much for donating. When I get back home, all of the knives should be they should be waiting for me when I get back home. The knives that we're gonna find some way to incorporate into making a donation to the GoFundMe. I'm not sure how we're going to do that yet, but we've got a plan. It's going to happen. So there's that. But for now, we're at $233,300, which is great. You guys have done fantastic. And again, I'll let you know when I can fully verify that this stuff is all taken care of. But I think it's about done right now. Let me just say that up until this experience, GoFundMe had been a great partner. Over the past couple days, my mood on GoFundMe has soured a little bit, mainly because I'm not 100% sure how truthful GoFundMe has been, and I'm not 100% sure how their practice of refunding donations, I'm not 100% sure it's actually legal, but I would much prefer to just do polite business with GoFundMe than to deal with something like that. But I would strongly recommend GoFundMe, if you're happening to watch this. I would strongly recommend that you guys be very cautious on how you deal with people donating money to on behalf of someone. And that money going to a law firm, how you deal with that. I would advise caution in that. Just prudent. Certainly research that with your own legal counsel and come to your own conclusions. But I would be curious on that. And if GoFundMe ever does any of this stuff with the freezing donations again, I will let you guys know right away, because there might have to be some sort of alternative in place if that happens. But I don't want to foreshadow anything like that. I just I'm not sure they handled that situation appropriately. Like, I think maybe they were accepting money from new people and using that to refund old donations from months ago that had already been paid out. And I'm not sure that that's legal to do. Just saying. And I don't know if the IRS would be too happy with stuff like that. But or other regulatory things, because that sounds more like a bank than someone who just allows funds to pass through a payment processor. So, but again, what do I know? What do I know? All right, next. Doug TeNapel and Ethan Van Sciver. Something happened between Doug and Ethan, and I have a policy, a long-standing policy. I don't get between two people's drama, especially if they're my friends. Ethan has always been friendly to me, so whatever his issue with Doug is doesn't transfer to me. And Doug has always been friendly to me, so whatever his issue with Ethan is doesn't transfer to me either. That's between Doug and Ethan. I don't know the full story. I can't tell you, but I don't think either Doug or Ethan would ask me to involve myself in that dispute between them, and I don't intend to in any way. I will let you know what I know, but right now that's really, really minimal. So I'm not gonna, like I said, I'm not getting involved in that. I think that these sorts of fights between creators really distract from the importance of maximizing audiences. I don't believe in weaponizing, especially amongst independent creators, weaponizing audiences of either person against the other. I think that asking people to draw and I haven't seen them do this, so don't get me wrong. I don't know that this is happening, but I think that asking people to ask their audiences to draw lines against other independent creators is a step that I don't go to. So, like I said, even in this dispute, I think if you're a fan of Marky or Monica, though I may think they should probably be out of this industry, I don't expect anybody to take my words and decide, I no longer like them as creators and I don't want to support their work. That's never been the intent, and I've actually encouraged people to go support them if they like doing that, to try and separate the art from the artist. Now, I know with independent creators, it gets muddier and muddier because the art is the artist in many ways. But like I said, I'm not involved in that situation. I don't know much about it other than I saw it at like 9 p.m. tonight was the first time I saw anything about it. So yeah, that's that. So anyways, support the guys you like. It's okay to like both Ethan and Doug. They're both great guys. Even if they have some sort of beef between each other, that just happens. So, all right. Next, where are we? We're about ready to start this document, right? Oh. Boomerang things on the back end. You guys will have no knowledge of what happened here that made me annoyed just now, but just know that I forgot to do one of my steps, and it will have no impact on you, but it will make my life slightly less convenient. All right. Okay. Let's do these chats, and then let's jump into this new document that we have from Beard Harris, Bullock, and Hughes. Right? That sounds fun. The Gun Kid says, did you hear the cyber terrorist organization known as Kiwi Farms has doxed Vic Mignogna? They even posted pictures of the inside of his house and compared it to Monica et al. Houses side by side. I did not know that. But I'm sure Vic will not be happy about that. But, you know, that's the thing with Kiwi Farms, right? Like, that's what they do. And they don't, for all of the bluster about Kiwi Farms directing and inciting harassment, which is patently untrue, they're kind of neutral on who they dox and all of that stuff. James Wolfgang says, Nick, quote, I'm not an expert. Aha, so you have no idea what the hell you're talking about. Bounces in chair like a giddy schoolgirl. Got him. What's the drink of the night, buddy? Milo's. Again, I'm in a dry county in a relatively dry house. So, no whiskey right now. Which is depressing. I mean, it's not really that depressing, but I like to have a whiskey while I do the show. I think it's fun. Charlie Spurs says, can guards at Area 51 really shoot you on sight for trying to get into the base? Yes, absolutely. You can. Guards at pretty much any military institution have authority to use deadly force. It's you don't get to go onto military property because they don't know your intentions. If you are unauthorized to be there, it's not recommended. Or do the same standards apply to civilians and police officers? Nope. As in it must be immediate perceived threat to your life, etc. No. Don't be unauthorized on a military installation. Don't do that. I cannot recommend it enough to not do that. So there you go. PGN White Knight says, greetings from Japan. Hey, buddy. How's it going? Thanks for the entertainment from Ise Jingu to Tokyo via Nagoya. I'm sure I ruined every one of those words. But hey, my pleasure. Reaver Barish says, which is worse, Landwee's filings or Moronica's TCPA? God, they're both bad in their own way. That TCPA, it's an abject disaster of a filing. What I love is really smart, dumpy people like Mike Dunford. Really smart dumpsters like him called it, I think, a stroke of genius. Like, they were so happy to run and fillet Lemoyne that they were calling that trash heap of a filing a stroke of genius. Very, very, very dubious assessment there, Mike. Wow. Night Blue Mage says, just want to say thank you for the shout out for Journey Quest for Kickstarter. I would like to think you help us get over 50K of the goal. Hey, cool, man. If you want to watch the other 3 seasons, they are free on YouTube under Zombie Orpheus. So there you go, guys. Journey Quest for Kickstarter got over its $50,000 goal. And you can go check the other 3 seasons on Zombie Orpheus on YouTube. So check that out. Seymour Butt says, Esquire Rackets, is that a hickey on your neck? Do I? Where? I don't think so. Maybe I got some sun. I don't know. I don't see anything. Is there going to be another Baby Rackets in 9 months? Signs point to no on that one. Phoenix Aurum says, thank you, Nick and community, for your kind words. I trolled Hero Hay and had some fun on his stream. Hashtag Brony Hay. I have a shot of bourbon here for you and my ma. Love you, Marilyn Darby. I miss you. Hey, thanks, buddy. Thanks, buddy. Best wishes to you. And again, thoughts are with you. West Nile Chan says, Rikeda-san, have you seen Lemwa-kun? I got a new protein coating just for him. Oh, no. Ryan Mercado says, I noticed that the majority of the lawyers attacking you are bald men because they got nothing else to do outside of Twitter. Giorgo for the win says, that GoFundMe situation is definitely sounding like a Ponzi scheme. LMAO, wink, illegal wink. It's a weird one. It's a weird one. Freighter J says, if Area 51 has a civil air patrol squadron, then Area 51 will be easy to infiltrate. The presence of civil air patrol equals the death of security at all military installations. So there you go. There you go, guys. All right. Let's hit these documents, right? Let's hit these documents. Oh, one more. Brosna, my man, says, I lived upstream from the Savannah River site where the U.S. made all the nukes during the Cold War, and they're the same signs there that they're the same signs that are at Area 51 there. If those signs are passed, there will be lethal consequences. Yeah, can't stress enough. Highly not recommended. Not recommended to engage in infiltrating that base. All right, let's do this. So we've got that's the Funimation TCPA. Here is the plaintiff's objections and motion to strike evidence offered in support of defendant Funimation's motion to dismiss. So here we go. Here we go. The Honorable Judge of said court. Plaintiff Victor Mignana objects to and requests that the court strike the following evidence which defendant Funimation Productions LLC, Funimation, offered in support of its motion to dismiss under the TCPA. Funimation's motion asks the court to dismiss plaintiff's claims under the Texas Citizens Participation Act, which is Texas Civil Practice and Remedies Code, Chapter 27. TCPA requires that Funimation show by a preponderance of the evidence presented that plaintiff's claims are based on, relate to, or are in response to Funimation's exercise of the right of free speech, to petition, or of association. Under a preponderance of the evidence standard, the fact finder must determine whether the movement's version of the events is more likely than not true. See NRE Lipsky. Hence, the admissibility of Funimation's evidence is a threshold question for the court. So objections to Funimation's evidence. Affidavit of Karen Mika. All right, let's get straight to that affidavit of Karen Mika. So that's this first one here, affidavit of Karen Mika. So we're going to go through as we get as we read what they're talking about striking, and we'll highlight those things. Intimidator0108 says, hey, Nick, how's it going? I just want to say thank you to everyone who commented, retweeted, and liked the tweet I did of the Tugmobile. It was fun to do, and I plan on streaming on Twitch the design of Nick's dream car next. Hey, cool. Cool, man. All right. Plaintiff objects to paragraphs 5, 7, and 9 of the affidavit of Karen Mika attached as Exhibit A to Funimation's motion, the Mika affidavit. All right, let's see. So 5, 7, and 9, I'm going to just go ahead and highlight these straight out. Is this not annoying? All right, so there's 5. Go with 7. And 9. Well, there's a lot of lines. Pick a shorter paragraph to strike. Oh my goodness. My mouse game is off point. Look at that. It's like Michael J. Fox doing the mouse here. Ugh. Okay. All right, so we're striking those for just for now. We'll take a look at the reasoning as we get going. So the highlighting is different on depending on whether or not it's a searchable document. Like if it's looking at this document like a picture, you get this freeform highlighter. And if it sees it as words, like here, your highlighter looks more like this, where it actually grabs the text. So that's why. So Phantom Cobra says, know anything about the big backer that stopped support of Fantasy Soft Entertainment over Vic recently? Nope. I heard something, not even that specific. I just heard there was something going on with Fantasy Soft, and that's it. So no, I have no idea. Okay. Ms. Mika testifies in paragraphs 1 to 2 of her affidavit that the facts in her affidavit are based on her personal knowledge as Funimation's vice president of operations. While a corporate employee is generally presumed to possess personal knowledge of facts that she would learn in the usual course of her employment, citing Brewer versus Green Lizard Holdings, LLC, her affidavit must affirmatively show how her position with the company makes her competent to testify to the facts she declares, i.e., how she acquired personal knowledge of the facts shown, citing Cunningham versus Zurich American Insurance Company and Barham versus Sugar Creek National Bank. Absent this evidence, the corporate affiant fails to provide the proper foundation for relevance and admissibility. This Texas Rules of Evidence 104. Quote, when the relevance of evidence depends on whether a fact exists, proof must be introduced sufficient to support a finding that the fact does exist. So, if I have Adobe Pro, you can OCR the document and make it editable. Yeah, I had no time to mess with that tonight. No time. I sat down, I got back to this place and sat down about 3 minutes before the show started. So, okay. In her affidavit, Ms. Mika does not show how, as vice president of operations, she obtained personal knowledge of the facts alleged in paragraphs 5, 7, or 9. For example, she does not testify that she read or that it was an essential role of her position as vice president of operations to read the tweets or posts mentioned in paragraph 5, that she oversaw or that it was an essential role of her position as vice president of operations to oversee the investigation mentioned in paragraph 7, or that she controlled or that it was an essential role of her position as vice president of operations to control the social media activity of Funimation's employees or contractors. In short, she failed to show personal knowledge of the facts alleged in these paragraphs. Cunningham. In addition to the general lack of predicate for her testimony, plaintiff further objects to the Mika affidavit as follows. Okay, so the first thing they're saying is these 3 paragraphs, let's read through them, okay? Well, I guess let's take a peek at number 2. I am vice president of operations at Funimation LLC. I have worked for Funimation since March. As vice president of operations, I am familiar with their business practices and its business relationships with employees and independent contractors, including with the voice actors who work for Funimation. Okay, so she has stated that as vice president of operations, she lays out, right, what she has knowledge of. I'm familiar with business practices, business relationships with employees and independent contractors, including voice actors who work for Funimation. Okay? So now, here's paragraph 5. On the same day that Funimation released Dragon Ball Super Broly, Funimation was tagged on Twitter by user @Hanleia with the question, "Hey @Funimation, why do you employ a known pedophile?" and a link to allegations of sexual misconduct by Mr. Mignana at anime conventions. The next day, on January 18th, 2019, Funimation learned of additional allegations of sexual misconduct by Mr. Mignana at anime conventions through negative Twitter posts from other sources within the anime community. So They're objecting to this entire paragraph because it is talking about social media posts that allegedly occurred tagging Funimation and in reference to Vic Mignogna, right? But her role doesn't give her, I guess, or she doesn't lay out how she has personal knowledge of these facts. So they strike them. So that's the idea, is take out this paragraph and then see what's left. Okay, so the next one, of course, is number 7 here. The investigation of Mr. Mignogna was handled by Tammy Denbo at Sony Pictures Entertainment. On or about January 29th, Tammy Denbo reported to me and Trina Simon that Miss Denbo had found that certain allegations of inappropriate conduct made against Mr. Mignogna were credible. Well, that's fine and dandy. First of all, that's hearsay, right? From Tammy Denbo. That's a hearsay statement. But second of all, what does she have to do as director of operations? What does she have to do with this investigation? She's director of operations, not director of human resources. She doesn't say that she has any involvement in investigation of employee misconduct or anything like that. All right. And finally, number 9, Funimation is not responsible for any tweets or other social media publications or commentary by co-defendants Monica Rial, Jamie Marchi, or Ron Toye. Is she in charge of monitoring the social media posts of these other people? Is she in charge of social media policy as director of operations? They have an affidavit from the social media director, right? That one's included. She doesn't say that. Again, up in paragraph 2, she says, I'm familiar with business practices and its business relationships with its employees and independent contractors, including voice actors who work for Funimation. How does she know anything about what these people are tweeting as a result of their job? So now what she could say is, it was reported to me by so-and-so, for example, and maybe cite to a business report or an email or something to go ahead and show why she has knowledge of this. Or I was browsing Twitter in my free time and noticed this thing. So Funimation does not have any control over what Marchi, Rial, or Toye publish on their personal Twitter accounts or in other social media. Rial and Marchi are not employees or agents of Funimation. As director of operations, they're saying that she's not able to. First of all, this is probably different. This is actually a legal conclusion on the agency and employment questions. Probably can't make this statement because this is a legal conclusion, but we'll get to that, I'm guessing. And they do not have actual or apparent authority to speak on behalf of Funimation. That's a legal conclusion as well. And she doesn't say why her job would give her this. What she could say is that Funimation does not hold them out as having authority, right? And she might know that is because of the business relationship knowledge, but that's not what she says. Mr. Mignogna and the other voice actors who work for Funimation, including Rial and Marchi, are independent contractors. That's a legal question. And Funimation does not hold any of these voice actors out as its employee or agent. Now this, she can probably make this statement. So the judge might, assuming the judge is pretty much completely deferential but doesn't want to get rid of this whole paragraph, judge might preserve this line, because she might have authority to say that. For his part, Toye is a fiance of Monica Rial. Doesn't say how she knows this. Toye is not an employee or agent of Funimation and has no relationship whatsoever with Funimation. Those are legal questions as well, especially agency. Agency is a legal question that involves facts, and then it's a matter of law. So, that's what they're attacking in this statement. Now I guess we can just stay right here for now. Let's go back to the motion to strike. So in addition to that, plaintiff further objects to the Mika affidavit as follows. So paragraph 5. In the 5th paragraph of her affidavit, Miss Mika testifies that on the same day that Funimation released Dragon Ball. Okay, so this is more specific to paragraph 5. And these are, okay, so that first one, this is an argument on her knowledge as VP of operations. All right. That's what we're talking about here. Her knowledge as vice president of operations. This now is an objection based on hearsay. All right, so let's do the hearsay analysis that that the drafter of this motion so kindly lays out for us. All right, so plaintiff objects to Miss Mika's testimony as hearsay. Miss Mika is testifying about statements, i.e. allegations of sexual misconduct, made by someone other than Miss Mika, i.e. by Twitter user at Hanlea, and other negative Twitter posts and other sources within the anime community, which are offered to prove the truth of the matter asserted, that the content of these statements asserted sexual misconduct by plaintiff. This is hearsay. Texas Rule of Evidence 801. Hearsay is inadmissible. Texas Rule of Evidence 802. Alternatively, under the best evidence rule, Ms. Mika was required to attach the actual allegations rather than summarize their content, and that's Texas Rule of Evidence 1002. And I need to see that one. I have these rules pulled up here. So let's pull that rule up. Rule 1002. Okay, 1002. Requirement of the original. An original writing, recording, or photograph is required in order to prove its content unless these rules or other law provides otherwise. So they're saying that they should have, I guess, attached the original writing here rather than a summary of Funimation learned of additional allegations of sexual misconduct, right? What additional allegations? Don't you tell me how to run my Adobe. All right. So that's the first one. We've got a couple chats here. The Gun Kid says, for the record, Veronica published Vic's address unredacted in their TCPA. Kiwi Farms just posted Vic's house to point out how Chad it is versus the virgin soy huts that all the players of Kick Vic live in. Super lol years included. Oh, they posted his address? That's nice. That was nice of them. But, you know, that's how these filings go, unfortunately. Andros Gaming says, thanks for doing what you do, Nick. Can you promote me as Lemoyne? If you want to help a new YouTuber, watch Andros. Oh, wait. Oh, I see what you mean. Can I promote you as Lemoyne? Sure. If you want to help a new YouTuber, watch Andros_gaming. He plays Minecraft, SAO, which I think is an anime show called Sword Art Online, Lick the Cost Thoughts, Sims, Mario Kart, and more, hoping to meet more good people from this movement. So there you go. That is the Lemoyne advertisement for Andros_gaming. Check it out if you like watching gaming on YouTube. There you go. Okay, back to it. Okay, paragraph 6. So I don't need to go through paragraph 5 because that's, well, I guess I could double. I'm not going to double highlight it, but we've already, they're trying to strike the entirety of paragraph 5. Okay, so paragraph 6. In the 6th paragraph of her affidavit, Miss Mika testifies that Miss Simon contacted Zach Hall, Executive Director of Human Resources for Sony Pictures Entertainment, to request the investigation. All right, so here we go. I directed Trina Simons to contact Sony Pictures Entertainment to request they investigate the allegations. Miss Simon contacted Zach Hall, Executive Director of Human Resources for Sony Pictures Entertainment, to request the investigation. Now let's see what they say about it. Plaintiff objects to Miss Mika's testimony as hearsay. Miss Mika is testifying about a statement, i.e. Miss Simon requesting that Mr. Hall conduct an investigation made by someone else, Miss Simon, which is offered to prove the truth of the matter asserted, i.e. that Miss Simon requested an investigation. This is hearsay. Texas Rule of Evidence 801, and hearsay is inadmissible. See how this is going? It's basic, it's boring, but that's how hearsay works. Michael Oosthuizen Oosthuizen says, which do you think burns the opposition more? Ty having a war chest or you earning more than them by explaining the case to us? I don't know, but I think with our planet or our powers combined, we are Captain Trash It. Paragraph 7. In paragraph 7, the second sentence of her affidavit, Miss Mika testifies that on or about January 29th, 2019, Tammy Denbo reported to me and Trina Simon that Miss Denbo had found certain allegations of inappropriate conduct made against Mr. Mignogna were credible. All right. So plaintiff objects to Miss Mika's testimony as hearsay. All right, let's get, so we have that one. Yep, we have that highlighted already. Miss Mika is testifying about a statement, allegations of inappropriate conduct made by someone else, Miss Denbo, which is offered to prove the truth of the matter asserted, i.e. that Miss Denbo determined certain allegations were credible. This is hearsay. Texas Rule of Evidence 801. Indeed, Miss Mika's testimony is hearsay within hearsay. She is testifying about Miss Denbo's statement, her report, which itself is based on statements supposedly made by persons other than Miss Denbo, i.e. allegations of inappropriate conduct. Hearsay is inadmissible. So there you go. That's a preview, by the way, of what's going to happen in Miss Denbo's statement. But you can actually have an affiant make a statement that is hearsay, even if that statement is backed up by the speaker in their own affidavit, right? Tammy Denbo is making these assertions in her own affidavit. Now, whether or not those are hearsay, I mean, you can see right here that he's arguing that it's hearsay within hearsay. So I'm guessing we're going to see him try to take out Tammy Denbo's report on the allegations as well. But for now, they could, in hypothetically, they could strike Miss Mika's statement and then hold in the actual affidavit of Tammy Denbo if it's not hearsay, if that section is not hearsay. So, but that might make Miss Mika's testimony still less valuable or weak, or it might mess with, you know, some assertion that they made specifically. So still go after it, because it doesn't matter that someone else says it in a way that is admissible. If it's inadmissible from this person, that could be of value to you in the case, but remains to be seen. All right. Paragraph 9. In the 9th paragraph of her affidavit, Miss Mika testifies that Funimation is not responsible for any tweets or other social media publications or commentary by co-defendants Monica Rial, Jamie Marchi, or Ron Toye. Funimation does not have any control over what Marchi, Rial, or Toye publish on their personal Twitter accounts or in other social media. Rial and that's a typo, Marchi are not employees or agents of Funimation. They do not have actual or apparent authority to speak on behalf of Funimation. Mr. Mignogna and the other voice actors who work for Funimation, including Rial and Marchi, are independent contractors, and Funimation does not hold any of these actors out as its employee or agent. For his part, Toye is the fiance of Monica Rial. I mean, granted, she thinks it's been for 2 years and he thinks it's been for like 12. But, you know, what does he know? I guess they talk about everything, just not the date that they got engaged. Toye is not an employee or agent of Funimation, has no relationship whatsoever with Funimation. Goober Gabber says, whenever the GoFundMe war chest is mentioned, Harry Enfield's Loads of Money starts playing in my head. It's clearly distracting the opposition from properly defending themselves. Isn't it, though? And isn't it funny that it is? It kills me every time. Plaintiff objects to Miss Mika's testimony. Now, this is different. This is not a hearsay objection. This is what I was talking about earlier, because she is making legal conclusions regarding questions of law. Whether defendants Rial, Marchi, or Toye had actual or apparent authority to act as Funimation's agent is a mixed question of law and fact. See Lyman versus State. Determinations of actual and apparent authority are reviewed as mixed questions of law and fact. Whether a relationship existed between Funimation and Rial, Marchi, or Toye that obligated Funimation to exercise control over their social media activity is also a question of law. See Greater Houston Transportation Company versus Phillips. The existence of a duty imposed by the relationship between employer and employee or independent contractor and contractee is a question of law. Boyd versus Texas Christian University. And that's stating that whether such a duty exists is a threshold question of law. Ms. Mika cannot opine on these questions of law. Texas Rule of Evidence 701. Let's take a look at that. Right? Here, Control F 701. You think this is going to work? Like the find feature ever did anything. Opinion testimony by lay witnesses. If a witness is not testifying as an expert, testimony in the form of an opinion is limited to one that is rationally based on the witness's perception and helpful to clearly understanding the witness's testimony or to determine a fact in issue. So that's it. They didn't actually give, let's see. This is about expert witnesses. Okay. So remember, all of these parties had the opportunity to offer up expert witnesses. They did. They were in their production requests for discovery. Now, they chose to ignore all discovery. They could have offered expert witnesses, or they could have tried to qualify her as an expert witness in the actual affidavit. So they could have tried that, but they didn't. They didn't do that. So she's not an expert. She cannot opine on these questions of law. And also see Good versus Maisie. The affidavit must set forth facts, not legal conclusions, quoting Queller versus City of San Antonio and Puente versus ASI Signs, which states that an expert is not permitted to give an opinion or state a legal conclusion regarding a question of law. See also Lipsky. Bare, baseless opinions and conclusory statements are not evidence. So, there you go. Strike paragraph 9. Okay, so that's what they're looking to do in this document from what's her face? From Mika. So let's see what Mika says. What's left? Okay. We'll take a peek. My name is Karen Mika. I'm over 18 years of age and of sound mind, and am fully competent to make this affidavit. And the facts stated here are within my personal knowledge and are true and correct. I'm Vice President of Operations at Funimation Productions. I have worked for Funimation since March 2016 as Vice President of Operations. I am familiar with Funimation's business practices and its business relationships with its employees and independent contractors, including with the voice actors who work for Funimation. Clint Mays says, first ever super chat. Hey, thank you. Keep fighting the good fight, man. You are a beacon of hope for all of mankind. Whoa! Do you want a beacon of hope for all of mankind if you're an orc? Okay, Funimation is a Flower Mound-based entertainment company that specializes in the dubbing and distribution of foreign content, mostly anime. One of the most popular properties distributed by Funimation is the Dragon Ball action-adventure franchise from Japan. Funimation hires voice actors who are independent contractors to dub Japanese productions into English. Funimation is a subsidiary of Sony Pictures Entertainment. Now, I mean, they might be able to attack that, but maybe not. And Sony Pictures Entertainment provides human resources related and legal support services to Funimation from time to time. Excuse me. Vic Mignogna has provided voice acting services to Funimation since 2004. Over that time, Mr. Mignogna has voice acted in more than 10 productions distributed by Funimation, including in features from the Dragon Ball franchise. In 2018, Funimation cast Mr. Mignogna as the English voice for Broly, the lead character in the fantasy anime martial arts film Dragon Ball Super Broly. Funimation released Dragon Ball Super Broly on January 16th, 2019. Now we go ahead and skip that one. Say, because of the allegations circulating about Mr. Mignogna, I directed Funimation's Trina Simon, Funimation's human resources manager, to contact Sony Pictures Entertainment to request that they investigate the allegations. Based on Mrs. Dembo's investigation, I concluded that Funimation should terminate its relationship with Vic Mignogna. On January 29, 2019, I contacted Mr. Mignogna by telephone along with Trina Simon and Zach Hall. On the call, I informed Mr. Mignogna that his conduct was unacceptable to Funimation, that Funimation was terminating its contract with him immediately. Funimation did not make any public statement about its termination of Mr. Mignogna at that time. That's it. I think they actually could have objected to this as well. Because she's not qualified to talk about that. But The rest of it is there. Now, of course, what's interesting about this affidavit is there's no allegations of sexual misconduct stated in the affidavit. And that makes, you know, an interesting issue for Funimation with the tweets and the implication that he is, you know, that he has committed some sort of sexual misconduct. So that's the goal there. Although I think in the request for relief, they actually asked the judge to strike the entire affidavit. But we'll get to that in a minute. Andre Neiman says, have $14.40, guys. South African rand isn't that strong against other currencies at the moment. Hi, Ricada Law. Thanks for covering the case. We love you, brother. No homo. Cheers. Hey, love you back. Full homo and no homo at the same time. Don't judge. Affidavit of Tammy Denbo. Plaintiff objects to the affidavit of Tammy Denbo attached as Exhibit B to Funimation's motion, the Denbo affidavit as follows. All right. In paragraph 2, in the second paragraph, fifth sentence, i.e. the last sentence of her affidavit, of her affidavit, I think it's the last sentence of her second paragraph. Let's see what it is. When my investigation began. Wait, what? Where is this? Oh, here we go. There it is. Weird. So that's a little typo. It's in the second paragraph, fifth sentence. Okay. The last sentence, the second paragraph of her affidavit. I don't like this sentence. I don't like it at all. Ms. Denbo, I get it now, but I don't like it because it confused me. Maybe it shouldn't have, but it did. Ms. Denbo testifies that when my investigation began, ellipsis, there were allegations on social media that Mr. Mignogna had engaged in inappropriate conduct with female fans at anime conventions. So, plaintiff objects to Ms. Denbo's testimony as hearsay and lacking a proper foundation. Ms. Denbo is testifying about statements, allegations on social media, made by someone else, not Ms. Denbo, which are offered to prove the truth of the matter asserted, that these allegations had been made on social media. This is hearsay. Hearsay is inadmissible. Furthermore, her affidavit fails to establish personal knowledge of these allegations. See Cunningham. Corporate affiant must affirmatively show how she acquired personal knowledge of the facts averred. And see also Jenkins versus Chemlon Products. Corporate affiant's testimony cannot be based on hearsay. Absent this evidence, Ms. Denbo's testimony about these allegations lacks a proper foundation for relevance and admissibility. This is Texas Rule 104, and we'll pull up 104, but it basically says, you know, it has to be relevant to be admissible. So here you go. 104. Preliminary questions. The court must decide any preliminary questions about whether a witness is qualified, a privilege exists, or evidence is admissible. In so deciding, the court is not bound by evidence rules except those on privilege. Relevance that depends on a fact. So what did they say here? They just say Rule 104 lacks proper foundation. Okay, hold on. When the relevance of evidence depends on whether a fact exists, proof must be introduced sufficient to support a finding that the fact does exist. Court may admit the proposed evidence on the condition that the proof be introduced later. Evidence relevant to weight and credibility. Okay. So yeah, it's just in general that it has to be relevant to the case. So there you go. All right, so let's strike that. So that's the last sentence of paragraph 3. When my... Ooh, this one converted nice. Investigations began. Sony Pictures Entertainment subsidiary had just released an anime feature in which Mr. Mignogna provided the voice, blah, blah, blah. And there were allegations on social media that he engaged in inappropriate conduct with female fans at anime conventions. So I want to strike that. Paragraph 3. In the third paragraph, second and third sentences of her affidavit, Ms. Denbo testifies that specifically I was given information by Funimation about allegations from, you can see immediately, right? You're starting to get the hang of this hearsay stuff, right? I was given information by Funimation about allegations from 2 female fans of inappropriate conduct by Mr. Mignogna that occurred at an anime convention. I was also alerted by Funimation that another of its voice actors, Monica Rial, wanted to share information about her personal experiences with Mr. Mignogna. There are ways around this. They could have provided business records that laid this out, right? You can do, to do that, you need a business records affidavit, and then it has to be supported by the business records themselves. Ms. Denbo is apparently a human resources investigator of some sort, or executive who does investigations. She should have business records of those investigations. They could have provided all of this. It could have been included in an investigation report. They didn't, though. Why? Why not? What is Funimation scared of reporting? What is Funimation scared of revealing with that report? Because they could have, that would not be hearsay. Business records are an exception to hearsay, and they didn't provide them. Why? Why? Oh my goodness. James Longacre says, first ever super chat. Hey buddy, thank you. I'm in school for paralegal here in Canada. You and your streams inspired me to get into law. Hey, well, that's great. What advice would you give someone just entering the field of law? It's a slag. School can suck at times. Go for it. Don't let people stop you. Don't let people discourage you from doing it. If you want to do it, go do it. Go do it. That's the one thing because you'll talk to lawyers and they'll be like, oh, don't be a lawyer. You'll talk to paralegals. Don't be a paralegal. If that's what you want to do and that's where your passion is and you want to fight for some sort of justice or whatever, go fight for it. Don't let other people dictate your destiny. How's that? I hope that's the best advice I can give you because law is a field of discouragement. So ignore it. All right. So plaintiff objects to Ms. Denbo's testimony as hearsay. What? Hold on. I gotta just check something real quick. Sorry, I gotta make sure this isn't something kind of critical. Oh, okay. Yeah, never mind. I'll deal with that later. Sorry. I just had to make sure it wasn't something that you guys needed to hear right now. Turns out it is not for this show at all. Plaintiff objects to Ms. Denbo's testimony as hearsay. Ms. Denbo is testifying about statements, i.e. allegations and want to share information made by someone else, i.e. 2 female fans and Ms. Rial, which are offered to prove the truth of the matters asserted, that 2 female fans made allegations of inappropriate conduct, that Ms. Rial wanted to share information about a personal experience. This is hearsay. Indeed, Ms. Denbo's testimony is hearsay within hearsay. She is testifying about out-of-court statements supposedly made by someone else, i.e. I was given information by Funimation. I was also alerted by Funimation about out-of-court statements supposedly made by different persons, i.e. allegations by 2 female fans. Ms. Rial wanted to share information. Hearsay is inadmissible. All right, so we'll go strike that. That was third paragraph, second and third sentences. So we can just go ahead and get rid of that one and that one. Gone. All right. Next, paragraph 4. In the 4th paragraph. In the 4th paragraph, 2nd through 4th sentences of her affidavit, Ms. Denbo testifies that I then interviewed Monica Rial via telephone on January 23rd, 2019 about inappropriate conduct at a female... Inappropriate conduct that she alleged was directed at her by Mr. Mignogna. On January 24th, 2019, I interviewed the 2 female fans who alleged that Mr. Mignogna engaged in inappropriate conduct at an anime convention. During my investigation, I also learned that a former Funimation employee had complained about Mr. Mignogna's inappropriate conduct while she was employed at Funimation. Plaintiff objects to Ms. Denbo's testimony as hearsay. Ms. Denbo is testifying about statements, i.e. allegations, made by someone else, Miss Rial, 2 female fans, and an unnamed former Funimation employee, which are offered to prove the truth of the matters asserted, that Miss Rial, 2 female fans, and unnamed former Funimation employee alleged inappropriate conduct. This is hearsay, which is inadmissible. So we'll get rid of that. That's 4th paragraph, 2nd through 4th sentences. Okay, here we go. That's just the rest of it. All right, so that is Miss Denbo's affidavit. All right, so here we go. Let's read what's left. My name is Tammy Denbo. I'm over 18 years of age, am of sound mind, and am fully competent to make this affidavit. And the facts stated here are within my personal knowledge and are true and correct. Now, of course, she's going to have a problem. How are these facts within her personal knowledge if she doesn't lay the foundation for how she got them? I am Executive Director of Employee Relations for Sony Pictures Entertainment. I have been in this role since March 2014. As Executive Director, I am the central point of contact for Funimation for employee relations concerns, including conducting internal investigations into employment and workplace-related matters. I perform scores of internal investigations for Sony Pictures Entertainment and its subsidiaries on an annual basis. As set out below, I investigated certain allegations of inappropriate conduct made against voice actor Victor Mignogna. Is it set out below? Maybe. On January 22nd, 2019, Sony Pictures Entertainment's Human Resources Department asked me to investigate certain allegations made against Mr. Mignogna. I'm not sure if they can, since she's the HR director, I don't know if she has authority. She must have authority to make this statement. Is probably why they didn't attack it on hearsay grounds. So then I conducted interviews of 2 potential witnesses on January 22nd. I then interviewed Monica Rial via telephone on January 23rd about inappropriate conduct that she alleged was directed at her by Mr. Mignogna. Okay. Based on my interviews, I concluded that the allegations of inappropriate conduct made against Mr. Mignogna were credible. I reported the same to Sony Pictures Entertainment Human Resources to be communicated to Funimation. So that's all that's left of Tammy Denbo's affidavit. Now, again, I'm guessing they're going to ask to strike the entire affidavit, but even if they don't do that, they can still attack all of these statements as lacking foundation, right? This is hearsay. These are hearsay exemptions or hearsay objections, and then objections to the legal conclusions in the other one. Once they get rid of this stuff, they can then attack the foundation of the facts asserted. So there you go. So now we're going to be on Scott Barretto. Here we go. Affidavit of Scott Barretto. That's, again, assuming only portions of the affidavits get struck and stuff like that. Affidavit of Scott Barretto. Plaintiff objects to the affidavit of Scott Barretto attached as Exhibit C to Funimation's motion. The Barretto affidavit as follows. In paragraph 5, I missed the 2nd sentence of the 4th paragraph. Oh, wow. Oh, there. Yeah, you're right. I did. Thank you. Thank you for bringing that up. So yeah, I conducted telephone interviews of 2 potential witnesses on January 22nd, 2019. I was thinking this looks like hearsay, but maybe they didn't agree. But no, it was just me missing the 2nd sentence. Thank you. So yeah, even worse. I conducted telephone interviews of 2 potential witnesses on January 22nd. Now, let's see what's left of that. So that's facts and evidence. Facts that will be in evidence is I conducted telephone interviews of 2 potential witnesses. Based on my interviews, I concluded that the allegations of inappropriate conduct were credible. That looks a lot less like a valid exercise of a human resources investigation. So, all right. Paragraph 5. So back to Scott Barretto. In the 5th paragraph of his affidavit, Mr. Barretto testifies that Allegations of misconduct against Mr. Mignogna began to receive media and social media attention in January 2019, with the publication of articles by Anime News Network and Polygon.com, as well as tweets and social media posts from members of the anime community. During this same time and through today, supporters of Mr. Mignogna, many of whom adopted the hashtag #IStandWithVic, again, that's how do you know that they're supporters of Mr. Mignogna who did this? Anyway, threatened and harassed members of the anime community and others who supported the women who alleged misconduct by Mr. Mignogna and who used the hashtag #KickVic. Threatened and harassed. Harassed may be a legal conclusion. Either way, this is hearsay. This is hearsay. Plaintiff objects to Mr. Barretto's testimony as hearsay. Mr. Barretto is testifying about statements, i.e. allegations, publications, tweets, social media posts, threats, and support made by persons other than Mr. Barretto, i.e. Anime News Network, Polygon.com, unnamed member of the anime community, unnamed supporters of plaintiff, and unnamed supporters of those making allegations, which are offered to prove the truth of the matter asserted, that the allegations had been made, that Anime News Network and Polygon.com published articles about the allegations, that unnamed persons threatened other unnamed persons, that unnamed persons supported other unnamed persons. This is hearsay. All right, so this is 5th paragraph. We'll just go ahead and hit this one as the whole thing there. Get rid of that. Paragraph 6. In the first 2 sentences of the 6th paragraph of his affidavit, Mr. Barretto testifies that. Now, do you guys notice something? The difference between this motion to strike and the TCPA that we were doing yesterday? You notice how this motion to strike logically flows down the document? How it's clear in what it's asking the court to do. It directs the court specifically to the passages while quoting them. It then lays out very clearly the arguments by laying out the elements of the arguments, giving examples, or the elements of the reason to strike, giving examples of the text, explaining how the facts, which is in this case, the facts are the words on the paper, apply to the law, which are the elements of hearsay or legal conclusion, with a case citation when necessary to not follow just a plain language rule. Like, do you notice the difference? This is what competent drafting looks like. It's easy to follow. A judge will have no problem. A judge's clerk will have no problem looking at this document and going, I understand every single thing that is being said here. I get all of it. I get it. It makes sense. They don't have to flip through. They don't have to look at sideways exhibits. They don't have mislabeled exhibits. They don't have miscited paragraphs and stuff like that. So far, the only errors so far have been my reading of something. It's amazingly different, and it's very, very important. Okay, the Gun Kid says, oh wait, no, Automata says, doesn't moving to strike as hearsay essentially tell Funny if they want to keep evidence, they need to produce business records, reveal specific authorship to their tweets, etc.? Seems like that serves a purpose. Yep, it does essentially tell them that. The problem that they're going to have is that they're beyond their 60-day window. They're beyond their 60-day window to file the TCPA. They're going to have to convince a judge that hard deadline that they got an extension on through a Rule 11 agreement should be further extended to allow them to prejudice the plaintiff with additional information. That's what they're going to have to convince the judge, that they have to, well, we didn't do it before, but now we want to. In our motion that we made, that we could have filed and then amended at any point up until that Rule 11 agreement on the extension, at any point up until then, we could have filed this thing and then amended and supplemented up until that point, and we decided not to. Now, if it gets struck, they're going to have to convince a judge that that needs to be further extended to allow them to amend their TCPA. I don't know if they're going to get that. discovery is stayed, but that doesn't mean you have to stop your own work. Like they can produce their own stuff in theory, but to amend their motion after being alerted that it's deficient in a material way, that's gonna probably be a problem for them. But I don't know. Maybe the judge will grant it. Who knows? All right. Where were we? First two sentences of the sixth paragraph. Mr. Barreto testifies that by late January, Funimation had received inquiries on social media and from the media whether Funimation intended to take any action or make any statement with respect to Mr. Mignogna. Due to the continued publicity surrounding Vic, including the allegations against him about inappropriate treatment of women, Funimation decided to issue a short statement via Twitter regarding its decision to end its relationship with Mignogna, which Funimation did on February 11th, 2019. All right. Plaintiff objects to Mr. Barreto's testimony as hearsay. Mr. Barreto is testifying about statements, i.e., alleged inquiries on social media from the media, the allegations, made by persons other than Mr. Barreto, i.e., unnamed social media posters, unnamed media, unnamed persons making allegations, which are offered to prove the truth of the matter asserted, i.e., that inquiries about Mr. Mignogna were made, that allegations of inappropriate conduct had been made. This is hearsay. Hearsay is inadmissible. Alternatively, under the best evidence rule, Mr. Barreto was required to attach the actual inquiries referenced in the first paragraph or the first sentence of paragraph 6 rather than summarize their content. We ran into this earlier. That's Texas Rule of Evidence 1002. Okay, so that's the first two sentences of the sixth paragraph. So, 1 and then 2. So here we go. Later in the same paragraph, in the 4th, 6th, and 7th sentences, oh God, now I'm going to have to count. Mr. Barreto also testifies that the purpose of the first tweet on February 11th was to inform the anime public of Funimation's decision to end its relationship with Mr. Mignogna. So that's the 4th one. They don't like that. And then we're going to have the 6th one. The purpose of this additional tweet was to respond to the continued heated back and forth among anime fans about Mr. Mignogna and was an effort to engage civility in the anime community. Here we go. And then the 7th line, which is Funimation nowhere stated or implied in any of its tweets that Mr. Mignogna had engaged in any harassment or intimidation, sexual or otherwise. Excuse me. Gassy. The Gun Kid says Erica McCord from Ahmed Al-Kawa. Erica McCord from Ahmed Al-Kawaida's affidavit just joined the Kiwi Farms 5 minutes ago to tell her story after being doxxed by them. So there you go. There you go. Very interesting. Lava Gust Fox, thank you for the donation. Bowser Jr.'s descendant says, I can't tell if this is hilarious or sad for Kick Vic. It's like watching a noob going against a world record professional gamer, and it's the noob's first time playing the game. MTC Dude says, why is there discovery stay during a TCPA filing to begin with? What's the legislative intent behind that? Legislative intent behind that is that discovery is very expensive. So if a lawsuit is filed just frivolously to cost the other party a bunch of money and not to actually resolve an issue that the court can intervene in, so if it's frivolous and it's just designed to punish through the judicial system someone, again, while being frivolous, it is perfectly acceptable to punish someone with a lawsuit so long as the lawsuit is valid. But if the lawsuit is frivolous, you can't use the judicial system as a hammer with a frivolous lawsuit. So what the goal is to avoid the undue burden of discovery. Discovery can be costly. Discovery can be embarrassing. Discovery can be professionally and personally damaging for people. So to avoid that cost, they allow you to challenge the validity of the lawsuit at the outset. I think it's a terrible law, frankly, because and the reason it's terrible, and Minnesota has actually struck down its anti-SLAPP statute. The problem is you're asking the court to judge the lawsuit on its merit without actually going through the process of having a trial. You're asking the court to make a judgment. You're taking away the ability to have a jury review of it. And actually, you're taking away the ability for the fact finder to have all of the facts, and the judge is just going to rule as a matter of law, because you couldn't conduct discovery, for example, that this must be frivolous, even if there's evidence that you could produce upon discovery. So it's very weird. It infringes upon your right to petition your government for redress of grievances against a fellow citizen, or even against the government, because the government can use a TCPA motion as well. I'm not a big fan of anti-SLAPP laws. In a weird way, I get the idea behind them. We don't want people frivolously sued over this stuff, but at the same time, they subvert the process that's there to ensure justice is carried out. So, anyway, okay. Plaintiff objects to this testimony because it lacks foundation, constitutes hearsay, and is inadmissible since the actual tweets are available. Though Mr. Barreto testifies that he is, quote, familiar with Funimation's media and social media related activities, and that he monitors media and social media posts related to Funimation, he does not testify that he wrote Funimation's February 11th, 2019 tweets. While a witness may testify to his own intent, Fuller versus Preston State Bank, Mr. Barreto is required to show how he would know Funimation's intent underlying its tweets. Remember, he doesn't say that he's qualified to, as social media director, unilaterally determine the intent of what's stated. It doesn't say that he is authorized to make tweets on behalf of Funimation in his thing either. Absent this evidence, Mr. Barreto's testimony about Funimation's intent lacks the proper foundation for relevance and admissibility. Moreover, if Mr. Barreto did not write the February 11th tweets, his testimony of Funimation's underlying intent is based on hearsay, for it must be testimony about statements, i.e. what someone told him was Funimation's underlying intent, made by persons other than Mr. Barreto, whoever wrote the tweets, which is offered to prove the truth of the matter asserted, Funimation's intent in tweeting the statements on February 11th. Hearsay is inadmissible. Rule of Evidence 802, see also Jenkins, corporate affiant's testimony cannot be based on hearsay. Further, since the best evidence of Funimation's intent, the tweets themselves, are available, Mr. Barreto's testimony of their content is inadmissible. Texas Rule of Evidence 1004. Oh, that one's different. Let's take a peek. Take a peek at 1004. Admissibility of other evidence of content. An original is not required, and other evidence of the content of a writing, recording, or photograph is admissible if all the originals are lost or destroyed unless a proponent lost or destroyed them in bad faith. An original cannot be obtained by any available judicial process. Original is not located in Texas. Party against whom the original would be offered had control of the original, was at the time put on notice by pleadings or otherwise that the original would be subject to proof at the trial of hearing, and fails to produce at a trial the writing, recording, or photograph that is not closely related to a controlling issue. I think this is actually supposed to be 1002 rather than 4. I think that's a typo, but because this is about tweets that aren't available, but these are available. But, well, you know, who knows? They might have to clarify that to the court. So, paragraph 7. So we got that. Architect of Fate says, after the discovery stay ends, can BHBH subpoena the business records since the investigation was conducted by Sony? If the investigation was improper, could that implicate Sony in a wrongful termination suit? The discovery stay will end when all of the TCPAs are resolved. If Funimation is still in suit after all of these TCPAs are resolved, I have a feeling they might be begging to settle. Nick Thorne says, have you heard the possibility of Vic not even working at the school in Moronica's first affidavit? Yeah. Or that the woman didn't even attend that school? I don't have exact evidence on me. Can chat help me out? I don't know about the woman not attending that school. She attests that she attended it, but maybe she didn't. I don't know. That would be very interesting. That would be very interesting. Paragraph 7. In the first, second, and fifth sentences in the 7th paragraph of his affidavit, Mr. Barreto testifies that Funimation's February 11th, 2019 tweets were truthful. I am aware that an investigation of Mr. Mignogna was conducted, that Funimation recast Mr. Mignogna in Morose Mononoke 2, and that Funimation will not be engaging Mr. Mignogna in future productions. In addition, part of Funimation's core mission is to celebrate the diversity of the anime community and to share its love for this genre and its positive impact on all, as stated in Funimation's February 11th, 2019 tweet. Furthermore, Funimation does not condone any kind of harassment or threatening behavior directed at anyone. No statement by Funimation in its February 11th, 2019 tweets is intended to defame Mr. Mignogna in any way, nor do the statements imply that Mr. Mignogna engaged in any harassing or threatening behavior. Funimation has not made any other public statement about Mr. Mignogna since its tweets on February 11th, 2019. That's got to be more than the first. Let's see, first, second, here's the first and second, and fifth, third, fourth, fifth. But they actually included the whole thing, so we'll take a look at this. Plaintiff objects to Mr. Barreto's testimony because it lacks foundation. Yeah, it's like they wrote first, second, and fifth and then decided to include the entire paragraph. Lacks foundation constitutes hearsay and is inadmissible since the actual tweets are available. Mr. Barreto does not testify that he wrote Funimation's February 11th, 2019 tweets, that he was involved in, or that the essential functions of his job at Funimation involved in participating in Funimation's investigation of plaintiff, Funimation's decision to recast plaintiff in Morose Mononoke 2, or its decision against engaging plaintiff in future productions. His testimony thus fails to affirmatively show how he acquired personal knowledge of Funimation's investigation, its decision to recast plaintiff, its decision against engaging plaintiff in future productions, or the intent behind its February 11th, 2019 tweets. Again, corporate affiant must affirmatively show how he acquired personal knowledge of the facts averred. Absent this evidence, Mr. Barreto's testimony about Funimation's intent lacks the proper foundation for relevance and admissibility. Moreover, if Mr. Barreto did not write the February 11th tweets, his testimony of Funimation's underlying intent is hearsay, for it must be testimony about statements, i.e. what someone told him was Funimation's underlying intent, made by persons other than Barreto, whoever wrote the tweets, which is offered to provide the truth of the matter asserted, Funimation's intent in tweeting the statements on February 11th. Hearsay is inadmissible. And again, see also Jenkins. Corporate affiant's testimony cannot be based on hearsay. Further, since the best evidence of Funimation's intent, the tweets themselves are available, Mr. Barreto's testimony of their content is inadmissible. See, that cites 1004 again. Maybe I'm just misreading it. They clearly want the entire... they clearly want this entire thing. So I'm going to strike all of it. All right. I don't know if I can do anime girl voices. It might depend on the anime girl. Paragraph 8 and exhibits D to W attached to Funimation's motion. Oh no. Oh no, let's take a look at this. True and correct copies of the following exhibits are attached to Funimation's TCPA motion. Plaintiff objects to the 8th paragraph of Barreto affidavit for its failure to show the requisite predicate for his testimony constitutes hearsay and fails to authenticate exhibits D through W attached to Funimation's motion. Also, plaintiff objects to exhibits D through W as unauthenticated and hearsay. So they want to go ahead and object to this, then all this. Oh, D through W, huh? There it goes. We'll take a look at those things in just a second. We'll take a look in just a second. In the 8th paragraph of his affidavit, Mr. Barreto testifies that exhibits D through W attached to Funimation's motion are true and correct copies. However, he does not proffer any evidence that he is a custodian of records or otherwise has any requisite personal knowledge to establish what each exhibit is. Texas Rule of Evidence 104 and 901. C. Cunningham. Corporate affiant must affirmatively show how he acquired personal knowledge of the facts averred. If he is testifying to what others told him about the documents or what the documents purport to say about themselves, that is hearsay, for he is testifying to out-of-court statements made by other persons offered to prove the truth of the matter asserted, and hearsay is inadmissible. I won't read that Jenkins quote again. His testimony that the exhibits are true and correct copies merely begs the question, true and correct copies of what? Mr. Barreto does not provide any testimony about what each exhibit is, or that each exhibit is what he claims it to be. See Texas Rule of Evidence 901. To satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. At a minimum, proof of authorship or composition or proof of a business record is required to authenticate these exhibits. Tienda versus State, discussing authentication of electronic evidence. Mr. Barreto makes no effort to provide such prima facie evidence of authentication. Indeed, Mr. Barreto does not even testify that the attachments are true and correct copies, quote, of the original documents. See Republic National Leasing Corporation versus Schindler. Authentication requires sworn affirmation that the attached documents were true and correct copies of the originals. Hence, paragraph 8 of Mr. Barreto's affidavit fails to authenticate exhibits D through W to Funimation's motion, and authentication is a condition precedent to admissibility. Texas Rule of Evidence 104 and 901, also Tienda. Moreover, exhibits E through I, K through M, and O through W are all hearsay. All are hearsay. Each is an out-of-court statement made by someone other than Mr. Barreto, which are offered to prove the truth of the matter asserted therein, and hearsay is inadmissible. Ouch. Let's take a look at these exhibits real quick. So true and correct copies of the following exhibits are attached to Funimation's TCPA motion. Mr. Mignana's January 20th, 2019 tweet. Polygon.com's January 25th article about Mr. Mignana. So proof of authorship, right? What did we talk about here? To satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. At a minimum, proof of authorship or composition or proof of a business record is required to authenticate these exhibits. So, who wrote Polygon.com? How do you, this Polygon.com article? No proof of authorship. What is it? Proof of, or composition or business record. There's nothing proving the Polygon.com article. There's no discussion that you reached out to verify with the author who wrote it. There's nothing. There's nothing about it at all. He doesn't even testify that he did a minimal amount of work to look at it. He didn't say, I, to the best of my knowledge and ability, believe, or not, I shouldn't say believe, I verified that this is a correct copy that was posted on this date and time and all of that stuff. There's nothing. There's nothing at all. So Anime News Network's articles, Polygon, Mr. Mignana's tweet, Anime News Network's articles. Now, Mignana's tweets are not hearsay because they're party statements. So those aren't, you know, they're statement of the party offered by the opposition. That's an exception to the rule against hearsay, or it's just not hearsay. Anime News Network's article, Funimation's tweet. Now notice they struck his, or they're trying to strike his testimony about the tweets, and they say the tweets are available, which is true. So tweets would be better evidence. Now they attempted to include the tweets, but they've also struck the tweets entirely. So they didn't provide, or they're attempting to strike the tweets on these grounds that they're not authenticated. Again, nowhere does Barreto testify that he makes tweets on behalf of Funimation, or that he authorizes tweets, or that he reviewed these specific tweets, or anything about it. He can't. He could provide the name of the person who tweeted it. He could say he authorized so-and-so to make the tweet. I directed so-and-so to make the tweet. I was directed to make this tweet, you know, stuff like that. So that's all of their exhibits. That's every piece of evidence that, that's everything that Funimation included. If they win this, there's no foundation for any of it. Wow. That's a bummer. Okay, let's read this, guys. Let's read his affidavit, what's left of it. So Scott Barreto. Before me, the undersigned notary public personally appeared Scott Barreto, known to me. Okay, blah, blah, blah. My name is Scott Barreto. I'm over 18 years of age and am of sound mind and am fully competent to make this affidavit, and the facts stated here are within my personal knowledge and are true and correct. I am Senior Director of Public Relations at Funimation Productions, LLC, which position I have held since September 2018. I have provided public relations related services to Funimation since 2015. As Senior Director of Public Relations at Funimation, I'm familiar with Funimation's media and social media related activities, and I monitor media and social media posts related to Funimation. Funimation is an entertainment company that specializes in the dubbing and distribution of foreign content, mostly anime. One of the most popular properties distributed by Funimation is the Dragon Ball action-adventure franchise from Japan. Vic Mignana has provided voice acting services to Funimation for several years, including in features from the Dragon Ball franchise. In 2018, Funimation cast Mr. Mignana as the English voice for Broly, the lead character in the fantasy anime martial arts film Dragon Ball Super Broly. Funimation released Dragon Ball Super Broly on January 16, 2019. A true and correct copy of Funimation's tweet is attached to Funimation's TCPA motion. It's not, though. At the same time, and in the same Twitter thread, Funimation added the following sentence to its tweet. Part of our core mission is to celebrate the diversity of the anime community and to share our love for this genre and to support its positive impact on all. We do not condone any kind of harassment or threatening behavior directed at anyone. So that was not struck for whatever reason. And that's it. That's his whole affidavit. If they get... Now, this is a motion to strike. The judge doesn't have to agree. But that's if they get their way, that's what they're asking. So, let's see. The court should strike Funimation's evidence. So they're asking for all of it. The Mika affidavit lacks the requisite predicate for her to testify about the tweets or posts mentioned in paragraph 5 of her affidavit, the investigation mentioned in paragraph 7 thereof, and the social media activity of Funimation's employees or contractors. Additionally, her testimony in paragraphs 5 to 6 of her affidavit contain inadmissible hearsay, and her testimony in paragraph 5 violates the best evidence rule. Plaintiff respectfully requests that the court strike the Mika affidavit or such portions that the court determines violate the Texas rules of evidence as argued above. Paragraphs 2 to 4 of the Denbo affidavit contain inadmissible hearsay, and she fails to provide the requisite predicate for her statements in paragraph 2. Plaintiff respectfully requests the court strike the Denbo affidavit or such portions that the court determines violate the Texas rules of evidence as argued above. Paragraphs 5 to 7 of the Barreto affidavit are based on hearsay. Mr. Barreto lacks the personal knowledge to testify to the matters in paragraphs 6 to 7, and his testimony in paragraphs 6 to 7 is precluded by Evidentiary Rule 1004. His testimony in paragraph 8 lacks the requisite predicate, is hearsay, and fails to authenticate exhibits D through W attached to Funimation's motion. Hence, Funimation's exhibits D through W are unauthenticated, a condition precedent to admissibility, and constitute inadmissible hearsay. Plaintiff respectfully requests that the court strike the Barreto affidavit, or such portions that the court determined violate the Texas rules of evidence as argued above, and strike exhibits D through W attached to Funimation's motion. Prayer. Wherefore, plaintiff requests that the court sustain his objections and strike the Mika affidavit, the Denbo affidavit, the Barreto affidavit, or such portions that the court determines violate the Texas rules of evidence as argued above, strike exhibits D through W attached to Funimation's motion, and award him other and further relief to which he may be entitled at law or in equity. Plaintiff prays for general relief. So there you go. Certificate of conference. Conference was held via email with John Volney, counsel for defendant Funimation, on the merits of this motion. Reasonable effort has been made to resolve the dispute without the necessity of court intervention. The effort failed. Therefore, it is presented to the court for determination. And then it was served today, or well, yesterday. Depending on where you are. Might still be today. Yeah. Even if you're mountain time, it's still today. Oh my goodness. So that's that. So what we're left with, if they strike the affidavits and the evidence, what's left of this? What's left of this thing? They have their introduction and summary of motion, which has no legal argument. Relevant factual background. So they've got the petition. They've got Exhibit A. This would have to be struck. Any of this, so this sentence would have to be struck. So the only thing they have right now is the petition. Petitions, by the way, the pleadings are evidence, and specifically the petitions are evidence. So let's go through and strike anything that is not from the petition that is cited. So this is petition. Anything that's id goes to citation before it. So petition id, that's fine. This is from petition and Exhibit A. So we can't actually strike this because it's listed in the petition. Now, maybe they amend their petition. I don't know. The next day, on January 18th, Funimation learned of additional allegations. That's from petition, paragraph 16, Exhibit A at paragraph 5. So this is confirming Vic's own view of himself as a public figure. He responded to the volume of negative publicity. His Twitter apology here. That's Exhibit D. So this has to be struck. This has to be struck. There we go. And then this has to be struck because it's referring back to this exhibit. So Exhibit D, if it gets struck, obviously this whole section's gone. So then we have, this is Exhibit A at paragraph 6. This is Exhibit B. Oh, wait, that's from the petition as well. The petition, I don't know what's mixed up in here. They might have to squabble over individual parts of this, depending on what is specifically in the petition and what's from the Denbo affidavit. But it's hard to say specifically. Okay. Based on our interviews. Okay, so this is Exhibit B. So that's gone. So then this is Exhibit A. That's gone, and that's Exhibit A as well. So, yeah, there's an update on Meier versus Wade because Meier had until the 23rd to file his response to, what was it? He had to till the 23rd to file a response to the motion opposing his amended petition. So we'll check that out in a minute. Or, well, I don't know if we'll check that out tonight. We might check it out tomorrow. We'll see. All right. So this is Exhibit E, gone. This is gone, Exhibit F and ID, which means that this, might have to be gone as well because its foundation is here in these bullet points. This is Exhibit G. This sentence probably has to go, but it's not actually cited, so I'm going to leave it in for now. So this is from Exhibits E through I and Exhibit C. This is from the petition. Okay, so this is from Exhibit J. So we've got to cut this out, scribble this out, and we got to cut this. So here we go. This is Exhibit C, paragraph 6. We're going to get rid of that. Get rid of this. That's from Exhibit L. This is also from Exhibit L. It's from Exhibit C, so this is gone. Do you see the problem with having all of your evidence struck out of these things? Is all from Exhibit C. For his part, Exhibit N, that's, again, all of this is gone. Exhibit N here, and Exhibit N, so that's gone. It's getting, what's left of this document is getting shorter by the minute. VIX, February 13th. Okay, so this is all from Exhibits O through W. Those are gone. And I'm going to leave this in, but this has to go because it's based on the same thing. So here you go. This is from the petition, so that gets to stay, this whole thing. This is there. Exhibit A, so that's gone. All of this is Exhibit A. Petition here. Toya is not an employee. That's a problem, right? They've lost their evidence that Toya is not an employee or agent of Funimation. So then here's the argument. Their argument is going to be lacking a lot of foundation if they black out everything. They've lost the evidence, by the way, of their public figure status on a lot of this stuff. Not all of it. Some of it is in the petition, but that will be weighed in the favor of the non-moving party. So that might be a problem. That might be a problem. Okay, let's check that. I don't know that the other parts of this argument cite to anything. They cite to case law and stuff like that. I don't know that they cite too much. Here's the petition. This is exhibits, so it's gone. IMDb page, that's from the exhibits, that's gone. That's from the exhibits, that's gone. That's from the exhibits, that's gone. Oh, these exhibits are gone too. This is really a shame, isn't it? If all of this gets struck, so that has to be gone. This footnote also is got to be gone because it's part of this exhibit stuff. Limited purpose public figure. What do we have here? Lane versus Ferris. This is a good citation, although I think it's distinguishable. Might have to go through that at some point. And so then here we go. Okay, so this is exhibits. Those are gone. Here, this is exhibits. This is gone. So, yeah, was a direct participant in the controversy because of this. Thus, So they've lost their evidence that he did this thing right here. That's a problem for them because they're relying on that. Okay, what else do we have here? All right. Is this all one sentence? This is all one sentence viewed in the larger context. So that's an exhibit. There we go. This one. Bear with me. We're almost done with this. Yep, we're going to lose this evidence and this evidence. Let's see. TCPA. There. Quotes. These aren't stated. Okay. That's fine. These are legal arguments, so these don't need citations to their evidence. Here we go. Exhibit A. That's gone. Id. That's gone. So yeah, they lose. This is devastating to them, losing this. If they do lose this, I mean, that they're not offering controverted evidence that these people are employees or agents. Okay, here we go. Get rid of that. Get rid of this. So there's that. Okay, here we go. All right. Request for attorney's fees, stay of discovery, and all that. Okay, so that's what's left here. I'm not going to read through this, but I just wanted to point out like how much of their argument goes away. So the only thing they get to keep are stuff from the petition specifically, and then their legal arguments. They lose their evidence. They lose their evidence for a lot of these claims, which weakens their arguments pretty significantly. Big problems. Big problems. And some of these things that are mixes of petitions and exhibits, those might actually have to have specific portions struck out if they lose them. I'm not going to go through that right now, but there's a lot of time. That takes a lot of time. Oh, and literally all of their attachments are gone if they win this motion. If Ty and Company win this motion in its entirety, that's what's gone, and what's left is a skeleton of the TCPA that they filed with no evidence attached to it, just legal arguments asserted baldly without foundation and without support except from the petition. And that's it. So there's also going to be stuff in their argument that references back to this that'll have problems because it was outlined or laid out in a different section before, and they're incorporating that into the argument, but that portion of their factual basis will be gone. And that's going to take a lot of time and a careful eye. I don't know that a live stream is the right place to do that, because that'll be a lot of like really reading through and going back and reading through and going back. But that's what happens when you have a team that has to deal with this stuff. That's part of the grunt work of law. Brian Dewig says, in a British accent, oh God, it's a nice petition you got there, Governor. Be a shame if someone set fire to it. I don't know if that was it, but that's what I got right now. I used to do a better British accent, and then I stopped doing them a long time ago. So who knows if it's probably terrible. I'm sure I offended the entire UK, because they're kind of offendable these days. Not the people, not individuals in the UK itself. What do you think their chances on succeeding with this motion will be? Depends what kind of mood the judge is in. I think they've got a good chance of getting some of this stuff thrown out. Whether the judge will want to go in and strike all of the evidence that Funimation provided that's a tough question. That's a hard thing to do. Like ignoring the law, ignoring anything else, a judge has to come in and say, I'm going to terminate your entire motion right now because they asked me to. And I guess, Volney, the attorney for Funimation, is likely going to, if nothing else, he'll have to, at the hearing, levy his defense for this. But he may be able to respond in writing with a written argument about why each of these things is not hearsay. And then if he does, we'll get a chance to examine that. And we'll get to say, okay, maybe he makes a good point here. Maybe he doesn't. John Volney seems to be a pretty good attorney. But it looks like some serious missteps were made. And I'm not going to blame John. Let me be very clear on this. I don't think that these missteps came from John at all. I think the defect in these affidavits specifically, this isn't John's fault. This is Funimation not wanting to produce the business records associated with the investigation and termination of Vic Mignogna. They did not fire him in writing, which is required under the contract that Vic was under. Vic is under contract with Funimation. If he's fired for cause, there's a termination provision in that contract. They didn't do it. We've never gone through that, have we? Do I have it here? Do I have it mobile? Let me see if I have it with me. I just do not have this folder synced. See if I've got it somewhere else. 1 second. I'm a little early on the stream tonight, guys. Would you like to go through this Funimation contract, the actor agreement? Because I've never actually brought it out, right? I teased it the one day, and then I got really, like, a bunch of stuff happened. So let's do it. Here we go. It's a work for hire agreement. Let me just make sure there's nothing in this that I have to redact. I don't think there is. Give me a minute. All right, we've got it. Let's take a look. There's nothing that needs to be redacted here. I can't tell you where I got this actor. Come on. I can't tell you where I got this agreement. I'm going to hit the GoFundMe real quick. See if we have any updates. Oh, we do. It's $233,370. Thank you to Unlimited Power and Anonymous and Andreas Wallen and Alice James. I'm guessing Unlimited Power might get refunded, so be prepared for that. We'll see. We'll see. But okay. Here's the contract. I can't tell you where I got this contract, but let me just suggest that what was represented to me is that this contract is a boilerplate contract that is signed by basically every actor without significant change. It's not like this contract is going to be different significantly, maybe in dollar amounts or something like that, which you'll see coming up, but maybe in dollar amounts or something like that. But in the actual terms of the contract, little to no negotiation is happening actor to actor. I can't attest to that I'm just telling you what's represented to me about this contract. That the person could be entirely wrong and every single contract could be wildly different. How much do you think that's true? With the amount of legal involvement that has occurred so far in the anime industry, how true do you think that is? I think that it's most likely that these people have signed this just straight out with no modifications, no revisions. I'm not sure any of them have attorneys that they rely on in any capacity. So I'm going to stick with that interpretation until I'm given some alternative. And if I am, I will relay that to you. But as of right now, it's been represented to me that this contract is representative of what every single actor at Funimation has signed. So there you go. Hearsay is inadmissible, Nick. Yeah, well, luckily we're not in court. I'm just bringing you guys evidence. Evidence that has no evidentiary standard other than I hope I have built the credibility and trust so that you know that I am producing a document that I received through my journalistic efforts, of which I have no investigative journalism credentials, that I have been routinely able to produce evidence in this case for journalistic purposes, not evidence for court purposes, but evidence for journalistic purposes that has routinely shown to be correct. That is up to you guys to determine my credibility in all of these things. And I hope that that credibility has built you enough trust to trust me here. And if it hasn't, well, just wait and see. Michael Connolly says, even after hearing about Sony/Funny violating so many of its own or state-defined policies, I am left less than shocked. This hypocritical thumb still exists, pushing workers down. What, if any, recourse do we have? They have more money than sense. The recourse? I hate suggesting this. I am opposed to unions as a matter of principle, but unionizing or organizing against this company has potential merit. The engineers almost unionized, and they got turned from independent contractors into employees. That's what happened with them, because Funimation was about to get boned hard. But it takes one actor to start standing up and renegotiating a contract, which means it takes one actor with a lawyer negotiating that contract. And you can't look at them as the only fountain in town that you can drink out. You have to be willing, just like in any negotiation, you have to be willing to walk away. If they want you, they'll take you. Funimation has built up this idea that you come to them and that they'll find someone else. Well, if they're going to find someone else, maybe you don't want to work there. Or maybe they're bluffing and maybe they can't find someone else. All right. Work for hire actors agreement. This agreement is between Funimation Productions Limited, a Texas limited partnership with offices at 1200 Lakeside Parkway, Building 1, Flower Mound, Texas 75028, and blank, social security number blank, an individual and citizen of the United States residing at blank. They're the talent. They're the talent. Remember, they see you as a talent. Whereas FPL is an entertainment production company, and whereas talent is a professional actor. And whereas, so these declarations get incorporated into the agreement. So both parties witness that these things are true and then move on to the now therefore. So whereas FPL owns or controls the rights to various audio visual programs and provides creative and production services for the same and similar programs, all of such programs being referred to herein individually and collectively as the property. This is an important definition to know, guys. So the property is the rights to audiovisual programs, creative and production services for those programs, and all of such programs being referred to herein individually and collectively as a property. So all of the programs, so Dragon Ball Z, Full Metal Alchemist, any Funimation show, Godzilla, for example, all of that stuff, or the English dubs of these things, is the property. That's going to come into play later. It's going to matter. For further clarity, the definition of property includes any and all audiovisual programs, along with all intellectual property based thereon and related thereto, for which FPL, formerly, currently, or at any time during the term of this agreement, owns or controls any rights, or for which FPL, former, currently, or at any time during the term of this agreement, provides creative or production services in any capacity. So the property means even intellectual property that Funimation owned in the past and no longer has the rights to produce in the future. For example, I don't think this is true, but hear me out. If Funimation had the rights to Evangelion, I don't think they did, but that was a different studio. Was that ADV or Gainax or something? Doesn't matter. Hypothetically, Funimation owned the rights to produce Evangelion. That lapses after 20 years or whatever, and now Netflix buys the rights to Evangelion. So the rights to produce an English dub of Evangelion have transferred away from Funimation or whoever owned them to Netflix. However, whoever did the English voice of Shinji Ikari in the Funimation version, again hypothetical, I'm probably wrong on I think I'm wrong, but I just am using an anime with names that I know. Whoever did the voice of Shinji in this version still identifies with that character of Shinji. Like when he goes to a convention, right? The voice of Shinji Ikari in the original English dub of Evangelion. Not the voice of Shinji Ikari in the Netflix version, who I heard did just an absolute terrible job. But those are distinct. The property that's defined in this contract sticks to the ownership that was Funimation's. So if you are the talent on that property, that will follow you. This matters because some of the talent are going to conventions on roles that they did 25 years ago, for example. All right. I hope that. Why wouldn't they pay royalties? They don't. They don't. And whereas FPL wishes to retain the services of talent on a work-for-hire basis and as an independent contractor to provide voice recording and or other services or materials for the property, and talent agrees to provide such services and materials, on the terms and conditions set out below. The materials are further defined to include, without limitation, all materials in any way associated with the property that talent has or shall voice, write, act, compose, draw, edit, enhance, direct, produce, or otherwise create in any way. So we're talking about the actual recordings. Like if you were to produce a recording in your own studio, for example, that's materials that are related to the property. If you have a script, that's materials related to the property. If you have some drafts of frames that are animated or whatever, those are materials related to the property, okay? Now, therefore, in consideration of the mutual promises contained herein, together with other good and valuable consideration, the receipt and sufficiency of which is hereby acknowledged, the parties agree as follows. As follows. Look at this. Oh my God. FPL, Funimation, agrees to pay talent the following on an independent contract basis as full payment. $35 for each hour of time logged within Funimation's recording studio located at 1200 Lakeside Parkway, Building 1, Flower Mound, Texas, or such other recording facility as FPL shall reasonably designate. I have heard that this number is now 75. I have heard that this number is now 75. But even so. And that's because of the union wages in Los Angeles are I believe $75. So they had to compete. Okay, so but for now, $35. As further clarification, talent understands talent shall not receive any royalties or residuals of any nature, and full compensation shall be stated as in 1A above. No royalties, no residuals. You can buy 10 billion copies of Dragon Ball Super Broly, and the actors will get 0.00 cents from that. So there you go. 75 per hour, sign you up. You don't get 40 hours of work in a week, buddy. You don't. Think about these things. You're recording 22-minute episodes. What, 23 episodes per season of 22 minutes? That's 22 minutes of episodes for most people is going to be one, maybe 2 hours of recording. You might be getting $150 an episode. Might be getting that. It's not a lot of money here. All right. So KOV, lol, the legal docs summons you presented on your show looks so weird to guys like me and Callie. Where's the Spanish, you complete racist? Almost all of our legal docs are half in Spanish. Hashtag woke and progressive. Michael Colony says, unionization is the idea that I've come up with, but now I'm curious what your arguments against unions are, other than the obvious corruption. I'm an engineer getting shafted, hence my intense interest. Michael, I'm against unions as a matter of principle just because of what unions become. They become bloated organizations that have a preservation interest that supersedes the rights of the workers. They want to preserve the union itself rather than preserve the rights of the workers. I'm not saying that unions are always the wrong solution. I'm just saying that my automatic assumption is against union. In this case, it might be the way. But what it does, unfortunately, absent a union, your options are to individually or to, with an unofficial union, for example, just get everybody to start negotiating hard. But that's a hard thing to do, right? Like I'm not saying that this is easy. Unionization provides a powerful tool with legal force behind it to go against these companies. So it may be the answer. That's what they did in California with the anime industry out there, and I think they get royalties on some anime productions out in California. If not, they get other protections like guaranteed minimum 2-hour rates per recording session, stuff like that. The Scott 16 says, so for the month that is these proceeding, Rooster Teeth decided that Death Battle will have Vic's most famous character lose horribly in a matchup that was more one-sided than Magneto versus Darth Vader. Coincidence? Who knows? Okay. Term. This agreement shall be in effect beginning on the date of signing and ending on December 31st, 2012. So these are 4 definite terms. The term shall automatically renew for successive 1-year periods unless either party shall provide to the other written notice of termination not less than 30 days nor more than 60 days prior to the end of the then current term. Trash Town TV says voice acting is generally crap money. Cons are where the money is, but only if you're a popular actor who's done many and high-profile roles. Yeah, that's what I've heard too. Talent shall appear and voice act for a reasonable time as needed during the term of this agreement. However, nothing in this agreement shall be construed to obligate Funimation to provide talent with any minimum amount of acting work, and all acting work shall be on an as-needed basis determined at the sole discretion of Funimation. So the reason that this stuff is important is this starts to lean towards who are they independent contractors or are they employers, right? And the critical test in determining, or employees, the critical test to determine an employee versus a contractor is summarized like this. How much control does the organization have over the individual? The root of independent contractors is independent. Are they setting their own hours? Are they requesting work? Are they being assigned work? How much control do they have over the work being done? Is there an employee director who's representing the company, directing how the person performs their task? Are they able to override the performance and suggest that the performance was insufficient for what they needed and demand them to re-perform without some sort of negotiation or contractual term that lays out how that works or how that dispute resolution takes place? Are they in control of you? Listen to how this reads. Funimation will tell you when you work, and then you work. Funimation doesn't have to give you work. They will tell you, and then you will do it. So this is not definitive, but this is weighing towards the employee versus contractor. Now, other stuff will weigh towards the contractor, probably. Talent shall at all times work diligently and shall perform faithfully, industriously, and to the best of talent's ability, experience, and talent, all duties that may be required of talent pursuant to the express and implicit terms of this agreement to FPL's reasonable satisfaction. That might sound like control, but this paragraph is actually kind of standard in a lot of independent contractor agreements as well. Talent shall be on a work-for-hire basis, and all materials created are and shall be the sole and exclusive property of Funimation from the time of their creation into eternity. So the independent contractor does not get to keep the rights to their work. They go to Funimation. That's going to lean towards employee. All materials are and shall be considered works made for hire, as such are defined under U.S. copyright laws, and FPL shall be the author and sole owner and proprietor of copyright and any other right, title, or interest in or to the materials. In the event that it should be determined that any of such materials do not qualify as work made for hire, talent shall and hereby does assign and transfer to FPL's talent's entire right, title, and interest in and to the copyright and all other rights, however acquired, that talent may have in the materials. Upon request, talent will take such steps as necessary to enable FPL to record such assignment. Talent hereby waives all moral rights in the materials. So all the rights to all of the things produced while working for Funimation as an independent contractor belong to Funimation. They own everything. Everything that you do, and if they for some reason don't own it, you will provide it to them. You will give it to them, including recording the assignment of those rights if it's necessary under law. Cabanaris Suzu says, "Preach it, Caucasian brother. If you don't read it on stream, you're just another big city cook." Of course I read it on stream. I try to always read it on stream. I need to check Justice Chats. Okay. Yeah, we're good. Let's see. Funimation shall have the right, but not the duty, to use talent's name, likeness, and resume in connection with the property and or the credits related to the property. So they get to use your image. You give up your right to publicity in relationship to the property. FPL shall have the right, but not duty, to use, adapt, edit, and again, solely at Funimation's discretion. Solely at Funimation's discretion, they shall have the right, but not the duty, to use, adapt, edit, add to, subtract from, overdub, revise, or alter the materials or any part thereof, to combine the materials with works of others, and to copy, publish, reproduce, record, and exploit the materials in all media and merchandise now and hereafter known without additional compensation to the talent. So they can take your voice acting and that you've done for them, and then they can redo either a part of yours or a part of another person's without any input or compensation to you. Talent agrees that all materials delivered to talent by Funimation are the sole property of Funimation, and talent may not duplicate, share, or dispense any of these materials. At any time, Funimation may request for talent to return or to destroy the materials delivered, and talent agrees to perform as requested. Talent understands that during the term of talent's employment, talent has in the past and will in the future come into contact with confidential information. This doesn't really point either way because this is normal for contractors and employees. Confidential information includes, but is not limited to, the following: all information relating to the methods and systems used to develop and produce a property and materials, all information related to the development and substance of all scripts, stories, plotlines, character developments, and like, which are not known to the general public, the terms and contents of this agreement, and of all past and future agreements between talent and Funimation, including but not limited to any information related to talent's compensation. Talent agrees that during and after the term of talent's employment with Funimation, talent shall... so again, they're exercising control after the term of employment. That's lovely. Talent shall keep secret... this is normal, of course. Talent shall keep secret confidential information and not disclose this information to anyone outside of Funimation without Funimation's prior written consent, except as required by law or for strictly necessary administrative purposes. With respect to such confidential information relating to talent's compensation structure, amount of compensation, or any other monetary or non-monetary benefits received by talent related to talent's employments by Funimation, talent shall not divulge this information to anyone, including other persons employed by Funimation. So you can't tell people how much you make. Talent shall not make any use of such confidential information for talent's own purposes or for the benefits of anyone other than Funimation. And upon Funimation's written request, talent shall deliver promptly to Funimation all software, data, memoranda, notes, records, and other documents, including all copies thereof, constituting or relating to such confidential information, which talent may then possess. There you go. They have to initial. That's these lines. They have to initial all these paragraphs. 10. Talent agrees that Funimation has the sole and exclusive right to talent services in connection with the property and materials. You tell me this is not an employee. You tell me this is not an employee. And that talent shall not, without the express prior written approval of Funimation, engage in any outside appearances, promotions, productions, or performances of any nature, either in person or recorded or broadcast in any medium now or hereafter known, which in any way relate to or make reference to the property or materials, including without limitation, secondary rights. You read that right, folks. You read that right. When a voice actor shows up to a convention with a big piece of art behind them that says voice of so-and-so, and it's a Funimation property or was a Funimation property at the time that talent recorded it, Funimation can tell them no under this contract. Funimation can tell any existing Funimation contractor, you cannot go to that convention associated with a Funimation property. That is really looking like an employee to me. How independent are you if they have full exclusivity? Anything, a radio interview, media, an ad, anything, promoting a toy, promoting a game, doing the voice of a game, like doing a voice for, a video game that's related to Funimation's rights in any way. Signing a picture of your character at a convention for money, Funimation can say no. That's a breach of contract. These aren't employees, right? Just independent contractors. Law Twitter says so. They're just independent contractors. Law Twitter says so. Next, parties understand and agree that the following prohibition shall apply only to jobs or projects, whether the following prohibition, whether paid or unpaid, which relate to the property or materials. Okay, so this is jobs or projects which relate to the property or materials. Talent shall, at no time during the term or for 18 months thereafter, so this is a non-compete clause right here, use or allow or permit anyone to use talent, talent services, talent's name, talent's likeness, or talent's voice, or a recording of talent's voice in connection with the creation, development, production, manufacture, promotion, distribution, packaging, or sale of any product, production, film, video, or broadcast, including without limitation a program residing on or accessed via television, cable, live stage, movie studio, CD-ROM, the internet, an online service, or any other media or other media now known or hereafter to become known. So this is an 18-month global non-compete that says that after 18 months with us, you cannot voice act for 18 months. You can't do it. 18 months, you're not a voice actor. Now this is, I don't know how Texas handles these non-competes. In Minnesota, this would be impermissible. Absolutely. Absolutely impermissible. This is way too broad. And so Minnesota adopts what's called a blue line approach to non-competes, non-compete clauses. And what they would do is they would take this, you can write whatever you want in their non-compete, and they would reduce it to what they find to be a reasonable non-compete. 18 months globally, so you can't do voice work anywhere for 18 months. In Minnesota, no way. If it's going to be a global restriction, it's going to be a very short term, 3 months, maybe 6 months at most. But they're likely going to reduce the geographical element of it to within a 50-mile radius of Funimation, or maybe within the same state, something like that. It's going to depend on case by case and job by job. But I don't know how Texas approaches that. Not an expert on that. This agreement shall be governed in accordance with the laws of the state of Texas and the state courts of Tarrant County, Texas. Yep. By the way, Funimation chose Tarrant County. So there you go. Shall have exclusive venue and jurisdiction over any dispute arising out of or relating to this agreement or the performance, non-performance, existence, validity, breach, or termination thereof. This written agreement contains the entire agreement between the parties and supersedes any and all other agreements between the parties. The parties acknowledge and agree that neither has made any representation with respect to the subject matter of this agreement or any representations inducing the execution and delivery of this agreement, except such representations as are specifically set forth in this agreement. And each of the parties acknowledges that such party has relied on such party's own judgment in entering into the agreement. Parties further acknowledge that any statements or representations that may have previously been made by either of them to the other are void and of no effect, and that neither of them has relied thereon in connection with such parties' dealings with the other. Oh my God. Blah. What an ugly sentence. Or paragraph. A waiver or modification of this agreement or of any covenant, condition, or limitation in this agreement shall not be valid unless in writing and executed by the party to be charged. And evidence of any waiver or modification shall not be offered or received in evidence in any proceeding, arbitration, or litigation between the parties arising out of or affecting this agreement, or rights or obligations for any of any party under this agreement, unless the waiver or modification is in writing executed by the party to be charged. So if you want to change any term of this, waive any term or modify any term, it has to be in writing and it has to be signed by both parties. What's this? Is this a termination clause? It sure looks like a termination clause. I can tell you how termination clauses work in Texas. If they're an employee, they have at-will termination. You terminate people for any reason. For no. Someone said it. Well, I think it was on Kiwi Farms. They explained it in a nice, blunt way. At-will employment means you can terminate someone for no reason, but you can't terminate someone for every reason, right? At-will employment does not allow you to terminate someone for being black, for example. Can't do that. But you can terminate them because you just want to. That's fine. Now, if you have an employee, you have at-will employment, and you can terminate them for any or no reason that is permissible by law. If you have an independent contractor, you must abide by the termination provisions of the contract. That's how it goes. If you have explicit termination provisions, then that's part of the contract. Otherwise, you breach. So, this agreement may be terminated by Funimation for cause upon written notice to talent. For purposes of this agreement, cause shall mean an omission, act or action, or series of omissions, acts, or actions of talent which constitutes, causes, or results in A, talent's failure or refusal to follow the directions of FPL in connection with providing FPL with the services and duties described herein. B, talent's failure or refusal to adhere to the terms of this agreement or to reasonable policies and regulations established by Funimation. Or C, talent acting in a manner which is detrimental to Funimation Productions' reputation in the community. Or D, the arrest, indictment, or conviction for the commission of a crime by talent. All notices and other communications required, permitted, or desired to be given hereunder must be in writing and sent by U.S. certified mail, return receipt requested, properly addressed to the addresses above, and with all postage or charges fully prepaid, by hand delivery or by recognized overnight courier service. Date of service by mail and hand delivery is the date on which such notice is received by the addressee. Each party may change its notice information by notifying the other party in writing in accordance with the foregoing. They have to deliver it to you in one of those ways in writing. No waiver by either party of any default shall be deemed as a waiver of any prior or subsequent default of the same or other provisions of this agreement if any term, clause, or provision hereof is held invalid or unenforceable by a court of competent jurisdiction. Such invalidity shall not affect the validity or operation of any other term, clause, or provision, and such invalid term, clause, or provision shall be deemed and severed to be severed from the agreement. So this is severability and non-waiver. Non-waiver means, let's say we go back to this clause, right? Funimation has a sole and exclusive right to talent services in connection with the property and materials, right? This one. Now, is Funimation actually telling people they can't go to conventions representing a character that was on a property that Funimation owned? Not normally, right? We can see that they're going to there. Are we to assume that these people are getting the express written consent of Funimation for every convention they attend? I highly doubt it. Now, some of them, Funimation sponsors these events and they book the people. Now, that's funny because Funimation does book people to show up at events and they have to. That's part of their job duties, which leans more towards employer. But they're not actually, I don't believe they're actually enforcing the writing requirement, prior written authorization to show up at a convention. Now, they could. What this means, though, is just because they waive that requirement and they say, sure, we didn't authorize it in writing, but we don't care, it's still part of the contract. And each individual waiver of that requirement means that the next time you want to do it, they can flex on you and say no at any time. They reserve that right forever. You don't get to just say, well, you didn't do it the last 10 times. Why are you doing it this time? They say, because we can. It's in your contract. So that's what non-waiver is. Severability means if the court finds any particular provision to be unreasonable, unconscionable, or unlawful, they can strike just that provision and the rest of the contract will remain. Without a severability clause, in theory, if they struck one term of the contract, the whole thing would be void. That's not how courts have worked for a while, but people throw in the severability just to be safe. So there you go. There you go. That's the contract. It's 4 pages. Talent must read the entire agreement and initial paragraphs 1, 9, 10, and 11 separately. Remember what 9, 10, and 11 are. These are your duties. Your duties to us. You owe us everything, and you get nothing. You get nothing but your $35 an hour or $75 an hour now. So that's it. So unless this contract has materially changed, you can tell this one was from 2012. Oh, goodness. Well, 2011 or 2012. You can tell that this is there. So unless this has materially changed significantly, which again has been represented to me that it has not, I don't know. My question for you, and this is, are these people independent contractors or are they employees? And by you, I mean Funimation. Funimation, are these independent contractors or employees? Kind of look like employees. A lot of them use your equipment in your facilities. Kind of looks like an employee to me. Maybe you disagree. Maybe the courts disagree. I'm sure Law Twitter disagrees. They're very smart and they know everything. They knew without ever reading this contract that they were independent contractors. Mike Dunford knew because it said independent contractor in the header. And that's what matters. That's what matters, right, Mike? It doesn't matter about the actual level of control exerted over them. But if Monica and Marky are employees, then Funimation may be liable for their actions. That would be a problem. If they're not employees, if they're an independent contractor, then they may be liable for breach of contract with Vic. Who knows? We'll see. I mean, someone says very poorly treated employees. I mean, I think that's obvious, right? These guys, you have to understand, the careers of voice actors are not made. The successful careers are not made in the recording studio. That's where it starts. That's the door. These guys have to go out and independently earn income by doing conventions and other projects. Funimation is a doorway to exposure. That's how they're treated. Funimation is providing you with the services of these people for peanuts and reaping the entire benefit. The entire benefit goes to them. None of it goes to the people you like. Isn't that amazing? The actors who bring the characters to life that you're buying, none of it's going to them. $150 an episode? Oh my gosh. Let's see. 3 hours? So one of my streams, 3 hours long, would cost $225? $225? I'm going to tell you guys, the average stream makes more than $225. So in theory, I could hire a Vic Mignogna to do the show. I could hire, at the rate Funimation is paying these guys, I could hire the biggest names in anime. I could hire them to do this show for less than I make on the average show. Now, how much does Funimation make per episode? Think about that. And guys, I would still turn a comfortable profit on many of these shows if I did that. Right? How much does Funimation make per episode? Now, they're paying a few more actors, right? They're paying a few more actors. They've got directors. They've got other production costs. How much do they make on this stuff? And remember, some of these recording sessions, they can record multiple episodes in one recording session, a couple hours. They've got them there in the studio. Say it's going to be a 3-hour session. That might knock out 5-6 episodes. What if they only have a couple lines? They're paying the people that you guys like nothing. And they're keeping that money. So, very interesting for Funimation. Very interesting. I'm not saying I could actually hire Vic to do it. Like, it's not the same thing. Like, I don't know that he would actually voice the show. It would be funny. It'd be funny. I doubt it. But I'm just saying the monetary aspect of it, right? Just think how much, like, this is a huge production. The shows that they do are huge productions that have tons of money-making ability for Funimation. Lots of licensing agreements that can go out to toy and video game manufacturers and all of that stuff. It's all controlled by them. You see it in the contract. They make a lot of money on this stuff. And my point in all this is that they are paying the people who bring it to life. The people that you pay to see aren't getting squat. Funimation's getting the overwhelming majority of it. So, just, I guess, think on that as you will. Let me say, Lane K 1978 says, typically anime series are only ever 12 to 13 episodes over 3 to 4 months. I feel the lack of royalties is because most dubbing studios do not own anything other than dubbing rights to the IPs, and Japanese studios who license it out but won't cede such rights. I don't know about that. Funimation makes money per sale in the US. Absolutely. They may be paying a royalty back to Japan, but they're making money per sale. And certainly having at least the title characters of the show. I mean, like, again, should Sean Schemmel not make some money from every sale of a Dragon Ball property, or at least a movie? I'm telling you guys, Dragon Ball Super Broly was not a separate contracted work. It's in this. It's these agreements. So it's not like, oh, well, for this big movie production we're doing, you're gonna come in and you're going to get royalties and all this stuff because it's a special thing. And just on the episodes, we're just doing this contract work. No, no, no. It's the same contract. It's the same contract. But yeah, I know you guys don't like Sean Schemmel, but he's the voice of Goku. That's my point. And a lot of people watch anime for Goku. Or watch Dragon Ball for Goku. So let's pick a better example. Vic is Edward Elric from Full Metal Alchemist. He's the protagonist of the show, one of the main characters. Shouldn't the main characters get, I don't know, 1 or 2 cents per sale of the show? Like per sale of a physical copy, a dime, 10 cents? No, they sells 100,000 copies. That's 10 grand of money, right? That's money. That's a lot of money, especially if, you know, you've got 22 episodes selling 10,000 copies, for example, or 100,000 copies, for example. That's a lot of money. And then maybe they get a quarter cent for every play on Funimation streaming service, or for every play on Amazon Prime, for example. You know, that's how these royalties work. The main characters of anything else, My Little Pony, I believe every single voice in My Little Pony gets a royalty from every single episode sale. American animation is treated very differently from Japanese, from dubbed anime, and yeah, it's crazy. So anyway, I wanted to bring all this to your attention. I don't know how much people know about this. So, there you go. There's that. Let's do super chats. I hope tonight's, if you're gonna leave, I understand super chats are not for everybody, but it has been my promise since the beginning of the channel to address all of them. If you're going to leave, let me just quickly offer a couple closing words to those who are leaving. Thank you for watching the show. I always hope this is informative. I always hope to bring you something you can't find anywhere else, and I trust that a lot of this information is new to many, many of you. So please stay tuned. We'll see what comes up as we go on. I don't know if Volney is going to respond to that motion to strike. I don't know when Beard, Harris, Bullock, and Hughes would set their hearing on that motion to strike. The rule says they can set it within 3 days of filing. Now, I don't know if the court has a hearing in 3 days, but it's possible that tomorrow they could set a hearing for, let's see, tomorrow is Thursday, Friday, Monday, Tuesday. We could have a hearing as early as Tuesday on that motion to strike if the court has availability. I don't know if they will, but that's a possibility. So we'll see. And remember, they've got a pressing deadline. They got August 8th. And the judge will need time to rule on that. So they may be pushing that August 8th hearing with regards to Funimation. Yeah, well, we'll have to see what's going on. Maybe they'll bump that hearing and set the motion to strike hearing on that date. I don't know. But yeah. So we'll see what happens. See what happens with all of this. Very interesting stuff. Thank you for joining me tonight. If you're going to leave, I'm about to hit all of these super chats, and then we'll start with the Justice chats. And then, yeah, I'll see you guys tomorrow. We should have a good show. All right. James Ridge says, Robert Mueller. I repeat the question. Oh, well, is out of my purview. I did not watch the Mueller live stream because I wanted to. I can't drink. The G Spot says, you have a form to prove you're a lawyer. Object to form, alleged lawyer. Nah, oi, I got a license. I got a license for my law practice. Let me see if I can show it on stream. I'll prove it. I might have to cover up. Oh, it's got my old address, my old law office address, since it, it expires on October 1st. I'll be renewing it then, and then updating my address. But here you go. Since it's got my old address that has been thoroughly doxxed or whatever. And this is my law office address. It was public, so I don't care. But here you go. There's my license to practice law. It's real. It's not focusing, but you know, there you go. Oi. You go to license for that. Yeah, that's my badge. Trent Michaels, it's not a dry county anymore, but that's very recent, within the past couple years. So there's not a lot of liquor stores here. You can buy beer and wine in the grocery stores, but actual liquor stores are harder. And I don't really feel like driving to the next county. Okay, why do we still have this up? There we go. Yeah. Oh, here we go. Now you can really see it. Bigger. Anyway. It looks Photoshop. Next. We've got Henry Aller says, "Hey Nick, planning a trip to visit to Minnesota from California, looking for a place to set roots. Mind if I email you with further questions?" You can email me. I don't know how much help I'll be. Dread Clown says, "Your Honor, I'm trying to depose the witness, but I'm dummy thick and the clap of my butt cheeks keeps alerting the prosecution." Where Tiger Ray says, "Didn't Monica say she contacted Tammy Denbo, I think you mean. Doesn't that contradict Karen Mika's affidavit?" I think Monica says she had contact with Tammy Denbo. Monica contacted Trina Simon, I believe, who then put her in contact with Tammy Denbo. That's in discovery from Monica or whatever. So we'll see. Irk Tenkaki says, "Would normally inadmissible evidence be allowed if it was leaked to the public and it was likely already accessible to a jury, or would it be stricken as hearsay and the jury instructed to ignore it if they were exposed to it?" Inadmissible evidence is inadmissible. So the jury and the fact finder would not be allowed to consider it. So, yeah. Fast Forward says, "Funimation will not be engaging Mignogna in future productions. Doesn't say contract is terminated." No, it said he was recast as Morose Mononokean, which means he was in an active contract. He was recast from that. Instead refers to Funimation exercising the provision they have no duty to use an actor on more projects, thus could argue no contract violation. No, they recast him on an existing project. And in either way, that's a breach of contract because they haven't, they haven't actually, how do I word this? I don't know. Trying to think about how to word this. He was cast for Morose Mononokean. The implication, I don't know the factual scenario around it, but the implication is that he had duties to perform and was terminated from those duties. So, yeah. They also informed him by phone, according to the petition, that he was terminated, as this isn't them saying, "Oh, we're not going to do it." This is them affirmatively saying you are terminated, but they did it improperly. That doesn't mean they didn't terminate the contract. It just means they didn't follow the provisions of the contract. Okay, so finally, Giorgo FTW says, "To play devil's advocate, isn't it true that you yourself said that the voice actors can submit affidavits to the Funimation contract? Or submit amendments to the Funimation contract? So to be fair, they could have amendments in place that has them getting paid more / accommodations." They could. Like I said, it's been represented to me that that's not the case. Doesn't mean, I said at the beginning, that doesn't mean that's true. I'm operating under that assumption until I see a different, until I get any evidence to the contrary. So far, I have received none. So next, Talenseer says, "Is this a measure of how many portions of a TCPA you can strike before the TCPA is functionally inadmissible?" Oh, yeah. Yeah. If you strike enough of the foundation of the TCPA, what is the TCPA? Mark Garza says, "From what I'm seeing, Broly was becoming canon in DBZ Super, so Vic would be a mainstay in the show, and Sabat didn't want that. We'll be watching the VOD. Good work, Nick." I've seen that floated. We'll say I've seen that floated. I don't know if that's true or not. What do we got here? What is it? Oh my God, how annoying. Sorry. Tim Forsyth 15 says beard forever. Blaine 20 says hashtag support fantasy soft. Breed a Jedi. Thank you for the donation. David Keegan says before every stream, there's always 5 thumbs down. Anyone else see the irony? Wingzer012 says all rise for the honorable Judge Regatta. Real Spider Phantom says I'm late, but you're later. Yeah, I clicked begin stream and I was just waiting for YouTube to actually begin the stream. That the internet connection was so bad at the beginning. I don't know. Formula 91 says free YouTube monies. Hey, thanks. Damian Storm says Nick is late. Chat objection non-responsive. Yorgamunda07 says late, low volume, and Lynn Hunt low volume. Well, that was just me being lower energy, right? Because I'm a guest at a house and I'm trying not to wake everybody up. My own house in the vault, you can't. The sound doesn't travel, so I can just belt out things, but not as much here. James Swacheno, thanks for donation. Blaine 20 says BHBH should invoice Funimation for doing their job for them. Oh, trust me. If they succeed in striking everything, then that TCPA looks frivolous and might be subject to sanctions. So maybe they will be invoicing Funimation for doing their job. Metalhead Martyr says first time donation. Hey, thank you. Thoughts on the Mueller testimony today? Seems like he wasn't all there. Well, you know, maybe he was being slowly poisoned by the Clintons. Dark Steel 1 says, thank you for all the great info. Love your streams. Hey, thanks. I appreciate it. Ajna Palm says Monica's Depot / TCPA included that she was a Funimation employee, but Funny's Depot / TCPA marked her as not an employee. Whose word is better? I don't know. Funimation, you've got problems, man. You've got problems. The other defendants they're going to have to throw you under the bus, or you're going to have to throw them under the bus. If you guys lose at TCPA, especially, then you have to know they have to throw you under the bus. Monica and Ron cannot eat that judgment. They'll be in the poorhouse for the rest of their life. They'll never be able to make money again. So they need that joint and several that joint liability with you, or they need you to indemnify them of their obligations based on respondeat superior. Funimation, pay attention. They're not your allies. They're not on your side. They're using you. You're not using them. Everything they did, I know you're trying to distance yourself from them, but everything they did is contrary to your interests. Nothing you did is contrary to their interests. You actually helped them in the defamation. It's pretty obvious that you did that. God, if I were Funimation, I would be looking so hard at settlement. I can't even believe that they haven't settled this yet, because they have the downside risk on this is massive to them. I'm pretty sure they've already stated. Boleto said, "Oh, we didn't say it was guilty of any sexual misconduct of any kind. We didn't say that." They're willing to put that under oath, but they're not willing to make that statement publicly. Why, in God's name, would you not do that if that could get you out of this case? It blows my mind. Ninja Work one, maybe Vic asked for like a whole bunch of money and they don't want to pay that or something, but man, I don't know. Ninja Work 111 says, should I feel bad that I fapped to one of Marky's characters? Yes. Nate Strojic says, finally glad to see you live. Not sure what to say, but keep up the work. Hey, thanks. That's sufficient. Alex Neves and Brita Jedi, thank you for the donations. Daniel Camargo says, Nick, how screwed is Jeffrey Epstein? Oh, dude. Ouch. I don't know. Doesn't look good. You don't want those charges. No one believes you. Even if you're innocent, no one believes you. I don't know if that guy's innocent. Plus, how screwed is he? If he has to name names, he's dead. He's dead in a heartbeat. Suppa Sandwich says 2 shekels for talking about Doug and EVS. Oh, thank you. Giorgo for the win says definitely sounds like a Ponzi scheme. Michael Connolly says, Nick, you seem a bit off tonight. Not in a bad way. Just kind of tired or down. You all right? Oh, I'm great. Again, I'm just a guest 1,000 miles from home. I have to be kind of quiet because the layout of this house is different and I don't want to wake everybody up. And I'm just, you know, I'm traveling, so I'm always tired. Hope so. You've been keeping the hope alive over here. Oh, I'm good though, buddy. I'm good. Voltic Enigma says, Kiwi Farms is a wild card in this situation. They don't care what party you're part of. They're their own party. Right. They just laugh. They just laugh at what they find funny. The Pie Baker says that filing was in fact a stroke of genius, a mentally debilitating stroke. Randstein Hernandez says, can't fool me, Nick. I know for a fact anime cat girls are being held in Area 51. I will get my waifu. Go get her, buddy. Just let someone else take the bullets. Extremely Happy Simmer says, I hope I made a boomer compilation of you and Ty. Check it out, please. I'll have to do that. Rate Yellow, thanks for the donation. Playmore says, everybody at Funimation hugged and kissed, apparently. First person to get accused of something is credible on that alone. Funny isn't looking great. Indie Visualist says, Ty Beard filed a response. Funimation has lost the case again. See, Kick Vic, I can do it too. Ad Brag. It's money for the law god. Hey, thanks, buddy. Matthew Farley says, look up in the sky. It's a bird, it's a plane, it's hearsay, and it's boring. Enter the QB says, Vic's going to dial up Karma Johns, ordering a large justice with extra facts and evidence. Hold the accusations. Mario Carter 13 says, it was a stroke of genius, emphasis on stroke. Aegis Thomas says, are independent contractors entitled to an unbiased investigation under their termination clauses according to the Texas Workplace Commission? If you're going to do an investigation, yeah, I don't know that the Workplace Commission investigation rules are binding. I don't know that they're binding. They're informative. They're informative. And if they're not followed, that might be evidence of them acting negligently in conducting that investigation. Unless they substantially do something to meet the spirit of the rules or whatever. Primus234521 says, TCPA, Kick Vic, this is bad comedy. Oh, wait. TCPA, Kick Vic, this is bad comedy. Channel your inner Megatron, Galvatron, Nick. First super chat and cheers for covering the situation. Man, I haven't watched the 87 Transformers movie in a while. Was it 87 or 89? Ah, it was good. Timothy Reaper says, what's with all the logic and case citations? Where's the drama, the action, the brave whammons? Does Ty know anything about writing legal documents? No. Windy City, GSH, thanks to the donations. Aegis Thomas. So this is a two-parter. Our Lord, Savior, and Liberator from ignorance and slavery, Lucifer Morningstar, along with the legions of hell and the Satanic Church, stand with Vic. They have a special circle of hell for Kick Vic. They're also fans of Full Metal Alchemist and Dragon Ball Super. The Emperor protects, but the devil attacks. Hashtag 666 for Vic. There you go. It was 86? No. It wasn't 86 on that movie. I think it was either the series was 86. I think the movie was 87 or 89. Wyatt Pierce says, Cuck20 soy approved condensed soy with ship. There you go. J Soy Lemosquito says, failed motion, not enough exhibit C's. Not enough exhibit C's. Philip Erdlejohn says, Nick, my fiance and I have been watching almost every broadcast. Best rant quotes get repeated a few times for the next week. Love Captain Trash It. Keep up the good work. Hey, thanks, buddy. Edimos 1000 says, I'm celebrating my promotion to management with some Glenlivet 12, Double Oak, and some law-splaining. Keep mocking them. Nothing breaks their spirit more than being out-memed. I agree. Ridicule. Let's see. Red Fox Moon says, please never stop being awesome, Nick. Heart, also, can you imitate anime girl voices or try to at least enjoy the free whiskey money? I mean, maybe I'd need some context on it. Aegis Thomas says, when Funimation tries to settle, can Vic set the condition of getting his role as Broly back? I mean, they could try. BHBH, listen up. It's for the fans. Hashtag vindication for Vic. You got the touch. Yeah. You got the touch. I love the scene in Boogie Nights when Mark Wahlberg is massacring You've Got the Touch. Oh, God, it's great. Cerulean Voice says, Hearsay is inadmissible remix win. Evade Nellis has served on USS Nebraska 24 ICBMs. Marines were specifically told to shoot and kill anyone stepping past the security barrier when nukes were being moved between storage areas. No frickin' joke. I believe you. I believe you. Double A, thanks for the donation. Mark Nicholas says, how many trees have been murdered so far for this case? All of them. Mariac the Gunslinger. Mariac the Gunslinger says, Hail Judge Nick, if it's okay with you, I'd like to shamelessly plug my comic Death's Metal. Of course. I hope to get it animated someday so I can have Vic voice the character also named Vic. Coincidence. So guys, check out Death's Metal. Mulker3 says, wait, Nick, do you mean corroboration of baseless hearsay isn't a sound legal strategy to damage someone you're jealous of? Someone should let him know. It's not a good one. Buster Cinema Satire says, how do you detect incompetent lawyers before trial? Unfortunately, by their actions. By their fruits, you shall know them. Infernal Iris says, what if there is no business record of the investigation, like it was just done behind closed doors? Kind of looks like a conspiracy then, doesn't it? Doesn't it? Oh, man. Aegis Thomas says, the question about independent contractors plus investigations was in relation to possible grounds for a lawsuit against Rooster Teeth. Just so you know. I don't know enough details about the contracts with Rooster Teeth. So who knows? I don't know how much control they exercise. It's completely different. Maybe. Austin Heartless says, Hero Hay is a brony. Hashtag Rising of the Brony Hero. Goober Gabber says, not sure if you missed my earlier super chat or if I missed you mentioning it, but I still punish you with $5 metric. Oh, thank you, I guess. Mulker3 says, are there strong workplace bullying laws in the U.S. and Texas? I have no idea. Miss Leia says, thank you for the entertainment while I chart. Oh, you're welcome. BJ Sparn says, just pay Vic the $75 to read super chats for an hour. Earjuice says, I earn more full-time an hour, yet won't watch anime because it's so expensive. Did you watch my Sheepdog Italo Disco song yet? Yo! No, I haven't. It's not personal. I haven't had time to, I barely had time to sit down and look at this stuff. I think tomorrow I have some free time, so I'll do that. Rando number 9 says, Masako Nozawa is my Goku. Sean can go Minecraft himself. Okay, yeah, there you go. I'm with it. Unbeknownst to X12 says, always a pleasure with the read. Fatman56 says, you should hire Vic just once and pay him more than fumigation. I find that to be such a funny reality. Have a good night. Okashi American says, Nick, please hire Vic to do your show as Drunkle Crow. Well, maybe. Hoystein says, can Vic sue over this contract? Maybe. And if so, how likely do you expect all their other contractors making a collective action? I mean, the IRS will really care. The IRS would really, really care. You should link to the comic Death's Metal. I can't find it. I don't have the link to it, so I couldn't tell you. It's Cocky Onside says, press F for Rutger Hauer. Gone at 75. Ladyhawk. Yes, Rutger Hauer is gone, but not forgotten. There you go. Freighter J says, is Funny still vicariously liable if they settle? No, that would be the term of the settlement. Is that the lawsuit would be foreclosed as to Funimation. Ishida Fury says, subbed over dubbed except for Full Metal Alchemist. Yakosai says, some shekels for the booze fund. How do you feel about Woodford Reserve? It's delicious, and I'm a big fan. Another great show. Thanks for all you do. Oh, thank you. Fatman56 says, Transformers 1986. I was in a theater watching my favorite characters die. I was too. I just thought I was a year older. When I saw it. No one important says, gonna have to rewatch it. I had the album on LP, man. No one important says, gonna have to rewatch this since I fell asleep. I dreamt everything you were saying was coming from my mom while insects attacked our house. That seems reasonable. Let's see. All right, that's it, guys. Let me get the Whiskey Lawyer song up. Whoa, goodness. Whiskey drinking lawyer. And Go. Here we go. The outro is playing. The outro is playing. Yeah, Rutger Hauer just died. Sorry to break that to you. Like just 5-6 hours ago. So pour one out for your man Rutger. The outro song is playing, which means the show is coming to an end. Thank you all for joining me tonight. It's always a pleasure. Always a pleasure to do this show and to engage with you guys. We will see what tomorrow holds. I don't know. Could be interesting stuff. Could go back to the TCPA of Ron and Monica. We could cover Meier versus Wade. We could do both. We'll see. There's so much to talk about. Asia Fraser says, Malice B, Nick 2019. F you a few very much, Tug 2019, just collecting stream quotes. Gabe says, any updates on the quartering assault case? Oh, he settled that. Jeremy settled the assault case. They made mutual apologies and requests to Gen Con to lift the bans on the other parties. Those apologies were video recorded and broadcast on Jeremy's show. So I don't know, you'd have to check that out. He's got it. I believe it's still up on his channel. So there you go. Did you read your Justice chat? Yes, I read all of the Justice chats. Oh wait, no, I didn't. Here it is. Somehow I missed it. Mercenary X says, please Nick, tell the chat to press F4. The death of Rutger Hauer. We just lost another legend in the film industry and the android from Blade Runner. I'm surprised he did Kingdom Hearts. And please go watch Razor Fist video on the death of a legend. Yes, so I thought I saw it, but I didn't. So there you go. That's that. So Razor Fist did a video on it. All right, guys. I'm hoping to bring the quartering to the show at some point. Yes, we just have to do that. Lawsuit review. I want to do. I need to get Beard and Bullock in the on the same time for that. We'll make it happen. We'll make it happen. All right, guys. I am out for the night. Thank you for joining me. See you tomorrow. Peace. Peace. Shores of Nairn to the hills of Glenlivet. There's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed.